Oh, hello. Good morning. Good afternoon. Good evening. Wherever. Hello. Hi, Indy. Good morning, sweetie. How are you? How are you? Well, it's been a long, busy morning for me. Yeah, now we're at our 3 o'clock, and I think I'm going to try and can't even talk, but keep a 3 p.m. time Monday through Friday. So it'll be a regular schedule. I think that'll work better. I don't know. Maybe I'm just thinking out loud. Anyways, so I'm just happy to be here today. I'm happy to be here. Happy to be here with y'all and get back to this. It's jury instructions today, and we're gonna zip through those on our Zoom speed that I love having the ability to do so much. So I think that's why I prefer to do these in the afternoon. It gives me that Zoom space. So, anyways, you're happy to be back too. We're going to jump right in. Get these jury instructions going. We'll have a few little funny breaks in between because, we have to take a moment to laugh. It's just life. So, anyways, I'm going to mute and let's go.
Day, the evidence has concluded in this case, and the court needs to address appropriate jury instructions. Ms. Stone and Ms. Zoe are present on behalf of the state. Mr. Kading is present with Mr. Ali, representing Mr. Ali, and Mr. Leary is present with Mrs. Ali and representing Mrs. Ali. Yesterday afternoon, after the conclusion of the evidence, I provided to the parties draft instructions and explained kind of how I put those together. I would just indicate, in case there's any questions, the copies I gave to the parties were double-sided. The original instructions will not be double-sided. I do run instructions continuously, i.e. not a single instruction on each page, but I will never break up an instruction between two pages when the final instructions are put together. As to, and as I refer to numbers, I am referring, of course, just to draft instructions, but I'm not going to repeat the word draft over and over again. So as to instructions 1 through 3, any issues with those, and I don't know if Ms. Stone or Ms. Zoe are going to be dealing with issues related to jury instructions.
I will. I'm sorry. May I remain seated while we have the conversation?
Of course.
Thank you. No issues with 1 through 3.
All right, Mr. Kading.
No issue, Your Honor.
Mr. Leary.
No exception.
All right. Number 4. The state and Mr. Kading submitted the same instruction. Mr. Leary submitted an instruction that has bracketed information from the WIPIC, which includes what is often referred to as the abiding belief language, the last sentence. And I have that bolded in the instruction so that it'll be clear that that was the issue that I would be addressing. Mr. Leary, I thought I would hear from you first.
As I'm sure everybody is well aware in terms of the arguments associated with WIPIC 4.01, it is not error to include that language. It is discretionary as defined by the comments and by the bracketed material in 4.01. I do object to language where the court is directing the jury as to whether they are satisfied beyond a reasonable doubt. I would also note that in the introductory instructions that the court provided to the jury when discussing reasonable doubt, the court did not include the abiding belief language, which I did note. Would ask to be consistent and simply object. And I'm not aware of this court's policy, and I know the courts generally have a standard policy. So that's my argument.
Thank you. Mr. Kading, your instruction did not include that language.
It might be.
I don't think so, but I could have missed it, certainly. I'm looking at your initial instruction, and you included the abiding, so you want the abiding belief language. Okay, because that's what was in your proposed instruction. Right. Yes, so that's, and I apologize if I wasn't clear. You did propose that language. Right. Yes, all right. And that's why I indicated on the draft instructions that it was only Mrs. Ali's instruction that had that language. Ms. Stone?
Thank you, Your Honor. Your Honor, I think counsel is correct as to the law regarding the abiding belief language. That is discretionary for the court. Obviously, the state would note that that language is regularly given. It is appropriate to give that language. The state's position consistently has been, when we are talking about reasonable doubt, that is not a objective measurement that the jury can look at information and say it's this percentage. There's no numerical value. And while we talk about it regularly as attorneys, especially as criminal attorneys in the course of the law, that has become, I would argue, a very we have much more familiarity to it. The first time that most jurors hear that as a measurement for deciding a case is during the course of the actual case when they're on jury duty. So they don't have that same familiarity. The state's position is and will remain that by giving essentially the opposite side of that coin, that helps the jury decide what otherwise could be I don't want to say amorphous, but a oftentimes difficult standard to apply with any level of certainty. So by giving them the opposite of of reasonable doubt with abiding belief, that is the opposite side of that coin, that helps give them another means for discussing with each other. If they have a reasonable doubt, I would ask the court to provide that as additional definition for them to help them make that consideration. It is appropriate, it is not error, and I think it is helpful to the jury.
Thank you. Anything further, Mr. Leary?
Oh, yeah.
All right. First of all, Mr. Leary raised the issue as to when I gave my opening information to the prospective jurors, to the entire panel, I give them what I tell them is a definition of reasonable doubt. And Mr. Leary is correct. I did not read the abiding belief language, and I don't ever include the abiding belief language when I give that just general definition to a jury. These are the jury instructions, which are different than the court giving a jury a general idea of how reasonable doubt is defined. And I would posit that no one will remember, first of all, exactly what I said at the time of those instructions. But the reason I don't give the abiding belief language is that I don't want someone who is a defendant to feel that they cannot suggest that if I give it, that means it will be in the final instructions. I want both sides to have an opportunity to argue that to the court. And so I don't want to read that on the off chance that someone would remember that they heard it differently. That's why I don't include it. It allows both sides the opportunity to argue to the court at the time of instructions whether or not I should include the abiding belief language. And I don't like to have a policy as it relates to jury instructions, as it relates to how I give jury instructions. I don't think that's appropriate. I think the court has to decide every time what are going to be the appropriate instructions in this matter. I find, and as the lawyers have properly indicated, if the court includes the abiding belief language, according to our pattern instructions, that's appropriate language and consistent with the law. If the court did not give the abiding belief language, that is also an appropriate instruction and consistent with the law. I am persuaded that it is appropriate, and I will include the abiding belief language in instruction 4. Any issues with 5 through 7, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
Ms. Stone, any issue with number 8?
My question, if it was necessary, Your Honor, in terms of the state going back through the evidence, I saw statements obviously that Mrs. Ali had made, which had come in, and statements that Mr. Ali had made, or I guess not made, but referenced in terms of arguments between his daughter and students at the scene, but not as it relates to each other, or that necessarily discussed the actions of each other. As the state's position is that Mr. or Mrs. Ali did not reference really her husband's actions at all. Her husband was referenced only in terms of what people were doing to her husband. So I don't think that it's necessary, and I think that it could be confusing to the jury in terms of how they identify what is happening in the case. That instruction number 8 is essentially a rule to address Bruton, and we don't have those types of statements here. There's no confession statement that implicates their co-defendant in terms of behavior. So I think this instruction number 8 is confusing, and I don't think it fits in this case, even though it is a co-defendant case.
All right, thank you. Mr. Kading?
Your Honor, I don't know what the final argument of the government is going to be, but I think that this instruction is necessary because I know there has been references to statements you made after this event that the state has been listening from the witnesses. Obviously, Mr. Raleigh was part of those.
Bless you.
So I think it's appropriate to limit the statements that she may be used in arguing the case against her, but not against Mr. Raleigh. So I would ask the court to include it.
Mr. Leary?
I can think of one example. One, I think it was Officer Bell, maybe Sergeant Bell, said that Mr. Ali told Mrs. Ali to just go home, given that my client is charged with burglary and has an argument with the chief and trespass. That statement shouldn't be used as evidence of the burglary or trespass. And that's too why. I didn't get a chance to cross him on why he wanted her to go home, because she wasn't supposed to be there, or just because the event was over and just go home. So I do think that instruction is appropriate.
And so I'm not making that argument. So insofar as that's helpful, I don't think that applies. That burglary plainly was committed prior to that statement being made. So I understand that concern. That's not an argument the state's making or would make, and I don't think that makes that instruction applicable. Yes, my concern is that Mrs. Ali describes what she sees as it relates to what is happening to her husband. My concern is that what if the jury looks at that and says, well, then do we need to take what Mrs. Ali said she says and cut Mr. Ali out of those observations altogether, even though it doesn't address any behaviors done by Mr. Ali. In fact, it's completely silent as to behaviors by Mrs. Ali, or excuse me, Mr. Ali. So that's my concern, is that it is going to be confusing to the jury in terms of how they apply it to Mrs. Ali's statements about her husband.
What specific statements are you concerned about would be confusing to the jury if this instruction were given?
Yes, Your Honor. My concern is that the way it implies is Mrs. Ali very specifically says she rolled up. She doesn't say roll up, but she and Honey arrive on the scene, and that she is watching a student beat her husband. They're punching him over and over and over again. Those were the statements that she continues to make. My concern is that the jury, in reading this instruction based on essentially the nature of it, that somehow then they have to pretend she doesn't say Mr. Ali and it's just a person or someone else, that they shouldn't use it that way. But because of the way that it reads, my concern is that somehow they will neutralize and take Mr. Ali out of that statement by Mrs. Ali, even though it's not attributing any actions to Mr. Ali and there's no statements regarding a confession or a conspiracy whatsoever. So that's the state's concern. I don't think it applies in this case for those reasons, and I think it can be confusing to the jury.
Mr. Leary?
The state said that they weren't going to argue, but that's not the only standard. You are telling the jury how they are to weigh the evidence and how they may use the evidence. And just because the state doesn't make an argument with respect to the burglary, it doesn't mean that the jury might not use Mr. Ali's statement.
All right. I am going to give instruction number 8. I think it is appropriate under the evidence that has been presented in this case as it relates to statements by the defendants. I do not believe that it's going to limit the state in how they can argue their case and the facts that have been presented in this matter as it relates to each of the defendants. Instruction number 9, the last clause of that instruction or of a third person was included in the instruction offered by the state and Mr. Kading. That clause was not in the instruction offered by Mr. Leary, and it appeared to me that it doesn't apply.
The state agrees with Mr. Leary's instruction, Your Honor.
All right, Mr. Kading?
I do too, Your Honor. I only included it because it wasn't bracketed, so I agree it's not relevant.
So what I have bolded in the draft instructions will be deleted. All right, Ms. Stone, any issues with 10 through 12?
Only on 10, Your Honor, I would indicate, I think we need a he or she does any act that is a substantial step.
All right. If I add or she, any issue with that instruction, Mr. Kading?
No, Your
Uh,
Honor.
Mr. Leary? All right, and I didn't ask you any issues with 11 or 12, Mr. Kading?
No, Your Honor.
Mr. Leary? All right. Any issue with number 13, Ms. Stone?
No, Your Honor.
Mr. Kading?
No.
Mr. Leary?
Yes.
All right.
So I guess at the outset, as evidenced by the pretrial brief and representations, the state had previously indicated, despite what was in the amended information, that they were not proceeding on an accomplice liability on the murder. I reached out to the state after I saw the draft instructions to say, had that position changed, or was this included in error? And they indicated that they did intend to offer this with respect to the attempted murder, and the specific explanation was based on Ms. Wagner's statement as to the actions of my client in terms of that she saw mom striking the man. And so her testimony was different from that, but regardless, I don't believe that there is, so I just want to be clear that the accomplice liability applies to the attempted murder, is that correct from the state?
Yes.
And only the attempted murder. So operating from that, so
No, I mean, she's charged as a principal or accomplice several times. If we're talking about the attempted murder, which I understood the question was, then yes, it applies to the attempted murder, and she has been charged that way consistently. I think that there are two theories that the jury could apply it on, either as a principal or as an accomplice. But both of those are available to the state. And what we did discuss very much earlier on in the case, a different scenario that much later in the case, as we talked about it, Mrs. Wagner's information is different. And I think the testimony at trial is consistent with the charging, and the state intends to argue that as well. I think there's two theories that the jury could find that on based on the testimony that has come out at trial.
I think I'm saying that. I wanted to be sure that I was only talking the accomplice theory in addition to the intentional theory on the murder too is the count of attempted murder is the only account where the state is proffering an accomplice, not the assault suit or the unlawful assistance. Is that correct or am I incorrect?
I think counsel is incorrect. I think that both of those apply. I think the stronger argument, certainly for both of them, for the state is the principal, but I think the accomplice liability applies for both. The state would be arguing both of those as charged.
Okay, that's all. Thank you. So the question then becomes, in the instruction, is there sufficient evidence for the jury to consider my client as an accomplice? And I'll start with the attempted murder too. If we look at the video, we know that in Exhibit 34, you can see at 213, you can see the Honda Element going the opposite direction on Mullen Road from the bus. And it then turns, the bus then parks, and then the Honda Element turns into the parking lot. The Element is already turning into the parking lot while the initial physical confrontation between Mr. Ali and Isaiah Boone. You can see the initial confrontation. So she then pulls into the parking, actually Haneen pulls into the parking lot, and on Exhibit 114, which is the Timberline High School video, we can then see her running across the parking lot. And there's been no testimony as to what is visible from there. We can surmise the distance. We know there are cars that she's running around, and there are kids surrounding Mr. Ali, Fatima Ali on the ground. We then look at Exhibit 89, which was discussed yesterday, admitted earlier in trial, which shows the arrival of my client standing next to the truck with the large Douglas fir tree in the middle of that still shot exhibit. So we know there's been no discussion about a conversation between my client and her husband about solicitation, a direction, commanding, encouraging, or requesting Mrs. Ali to commit the crime of attempted murder. There's no testimony that she agreed to aid in the planning of the commission of the crime. So the sole question is whether or not she aided Mr. Ali in the allegation that he committed attempted murder. We know that mere presence and knowledge of criminal activity, so more than mere presence and knowledge of criminal activity must be shown to establish that a person who is present is an accomplice. That's in the instruction. So, and then there's case law that talks about it's not should have known, it's that they actually knew. Now, the state has made a large effort, or has addressed this topic repeatedly, that at no time did my client tell the police, talk about strangulation, or talk about or seeing her husband strangle Fatima. She talks about the repeated punches to his head over and over and over again. Furthermore, the court is well aware of the positioning of everybody. So we have Mullen Road, we have Fatima on the ground, we then have her dad either on top or laying in between Mullen Road. So Fatima, Mr. Ali, and the school, the direction in which she's coming. There's been no testimony that in terms of what was visible from the parking lot. There's no pictures or evidence that detectives went afterward to basically show what is visible from the parking lot. There's nobody says it was very clear from where I was standing next to the truck or between Mr. Ali and the truck that it was very clear that what was happening. What she says is I could see him being struck in the head by Isaiah. So the state has to prove that she has actual knowledge that he was attempting to kill her, and that she then, with that knowledge, agreed to assist in the commission of that crime. And there simply isn't sufficient evidence for the jury to be instructed on attempted murder 2 as to attempted murder. So then the next question is, as to assault 2, with respect to strangulation, same argument. You know, she comes up, and we know from Mr. Wagner's arrival, he comes from one side where he can actually see Fatima, intervenes, and his testimony is Dad immediately, he removed Dad's arm with some force, but there really wasn't much of a struggle. And he basically was able to immediately stop Mr. Ali and the actions of Mr. Ali. So then we go to the unlawful imprisonment. Now, the court noted yesterday in the halftime motion that strangulation isn't a part of reasonable parenting, but we have to look at it again from the eyes of my client. She sees, presumably, we don't actually even have testimony that she did see or could see or made eye contact, but there's an argument circumstantially that she was able to see her husband and able to see her daughter as they passed by the bus stop on Mullen Road. And in the video, 34, there is nothing that's happening at that point. There's been no physical struggle, there's no punches, there's no strangulation. So she pulls into the parking lot, she knows presumably where they are because that's where she ran. There's no testimony that anything that happened beyond those kids is visible. She then runs through cars, sees arms punching her husband's head, goes into the crowd, same time Wagner stops Mr. Ali. She then grabs her daughter. So in the split second that this all happens, mere presence and knowledge of criminal, more than mere presence and knowledge of criminal activity must be shown. If we're talking also about self-defense, we talk about mistaken belief, right? Which is a somewhat analogous here. There's nothing to suggest that he says, I'm going to kill my daughter. And that was the purpose of going to the school. So there's nothing to suggest, again, that solicitation, command, encourage, request. The only issue is whether she aided him in attempting to kill her daughter in the fraction of a second where she arrived with Mr. Wagner and he defused. There isn't a basis for accomplice liability. Now, the state is also arguing, and I'm not arguing for a halftime motion, as that the actions of my client as she's holding her daughter, the state is alleging assault 2 for that and unlawful imprisonment. And I'm prepared to argue to the jury against that, but to say that she is an accomplice to what happened before she arrived and in the fraction of a second that she's there, I think is an abuse of the accomplice liability statute and legal theory.
Just one moment.
Judge is writing or thinking or something. She said 1 minute. But I have it on 1.25 speed, so I don't know how fast she can come back. I don't think it's too fast, but.
And says that she sees her husband being punched repeatedly. We saw that from the the body cam video of Mrs. Ali's statements that she sees her husband being punched repeatedly over and over and over again. She in fact demonstrates that to Officer Chavez over and over and over again. Those punches can only be happening while her husband is strangling her daughter. Josh Wagner, who quite plainly gets there after Mrs. Ali, that is on video. That was also what Mr. Leary just indicated in his argument because that's consistent with the video. Mrs. Ali arrives not long before Josh Wagner, but just before Josh Wagner. Josh Wagner, who knows none of these individuals from Adam, immediately says, as he's walking up, he can see that this man is strangling a young girl. Initially, as he is stopping his vehicle, he believes it is a group of kids fighting another kid. He says as soon as he's out, he can see that it is a man strangling a child. Mrs. Ali arrives at that scene just prior to Josh Wagner, not long prior, but just prior, And instead, she, who knows both of the parties, she obviously knows where she's going to get to that bus stop in the first place. So she has communicated with her husband in some way. That is the state's argument, because otherwise she has no way to know to go to the bus stop from where she is sitting, even by Mr. Leary's own argument, out in the parking lot, if that communication has not happened. So of all the people there, even if she knew none of that, she knows who those individuals are. And so everybody there who doesn't know anyone else from Adam clearly sees and testifies immediately that they can see a grown man strangling a child. Mrs. Ali arrives on scene, and instead of assisting her child, immediately starts pulling and striking the children that are there to get them away from her husband. And all of her concern is about her husband. So she's already on the ground at the time that happens. She absolutely is an accomplice to that attempted murder. She is not helping her child. Counsel can make the argument that he doesn't believe the accomplice liability theory applies, or that the state has not met that burden. But all inferences should go in favor of the state, all of those reasonable inferences, and it should be provided to the jury to make that assessment themselves. Certainly, she is more than simply on scene and present. That application actually in this case would apply, I would argue, to the kids who are videotaping, to the people who are watching and don't know what to do, not Mrs. Ali, who immediately jumps in, inserts herself, and is not there to assist her child. It does not appear based on the testimony that we have received. So the accomplice liability absolutely is appropriate for that, for the unlawful imprisonment as well, because then immediately upon being released, despite all the information to the contrary from the spectators, she immediately goes into choking her child as well as restraining her child while her child is trying to get away from her, in exactly what everybody else says they saw and that she was there at the same time to see. Everybody identifies that after Josh Wagner does whatever Josh Wagner does to restrain Mr. Ali and have Fatima released from Mr. Ali, all of the striking stops. That is consistent with the video. So if Mrs. Ali is there to see repeated strikes over and over and over again, then she is also there when that strangling is happening of her child, and she knows those parties better than anyone else. So the accomplice liability absolutely should be given in that case.
Mr. Lurie, anything further?
I'll leave it up to the court. I think I would encourage the court to go back and watch the short clip in 34, where you see the arrival of Mr. Wagner and you see the arrival of my client. If you have questions as to the representation of the parties as to what my client did and what appeared to be visible to her.
All right. Certainly the court viewed that clip, which I believe was played multiple times during the course of the trial. And so I'm familiar with what I saw during the course of the many playing of that video. And I would posit that I saw more and more as I watched it time and again, based upon the questions that were being asked of any particular witness who was viewing that footage. Certainly as it relates, the information, which is not ultimately controlling as it relates to the jury instructions, it's whether or not there has been evidence presented, if with inferences, with reasonable inferences to the state, whether or not an instruction would be given, even regardless of how how the matter is charged within the information. I do find that there is sufficient evidence, and when I view the evidence with reasonable inferences to the state for their argument of accomplice liability as it relates to Mrs. Ali, as has just been argued on the attempted murder charge, the assault in the second-degree charge, and then I don't know if you want any further argument as it relates to the unlawful imprisonment, but I also would, it's all of those things are linked together in the time frame, and so really I find that there's sufficient evidence with all reasonable inferences for the accomplice liability for all three, for the attempted murder, for the assaults too, and for the unlawful imprisonment. And so I will be giving instruction number 13. On number 14, the WIPIC indicates that when there is an attempt, that there needs to be an elements instruction separately delineating.
Oh my gosh, Maria, now you've got me like listening to all her ums. She's like, I don't know if it's because it's on fast speed or what, but she's saying like every few seconds. Oh my Lord. Go ahead, Maria. You got that in my mind now.
The elements of the crime. The state proposed number 14 when I viewed that, it appeared to me that the last two paragraphs in the proposed instruction are not appropriate because only the elements, by my reading of WIPIC 100.02, should be included in that instruction. So, Ms. Stone?
No objection to that, Your Honor. State agrees with that deletion. I would also ask, essentially anywhere it says FIA at this point, we just, based on the way the testimony came out, that we just change it to the name Fatima Ali, and date of birth obviously isn't being needed, excuse me. And
so,
that will be throughout the instructions.
all right. Mr. Kading, as to instruction 14 with the suggestion that the last two paragraphs be deleted, up in the first paragraph, it still says the elements would need to be proven beyond a reasonable doubt. So that is still part of the instruction.
Correct, and I agree with the court's analysis on that.
All right, Mr. Leary?
I agree with the deletion of the last two paragraphs. I have no objection to using Fatima Ali. I would object to the inclusion of her birthday because I think it's a common evidence to establish her age.
No, I said not to include it.
So if the court didn't go with your suggestion, I would note an objection. And then with respect to element 1 and 2, it says a defendant. I would ask that it say the defendant. My concern is that if they were to convict one defendant, it would necessarily result in the conviction of the other.
Ms. Stone?
I don't think I have an objection to that.
All right. And Mr. Kading, any objection to me using the name Fatima Ali and removing the date of birth?
No, Your Honor.
All right. Any objection as it relates to the defendant versus a defendant in elements 1 and 2 of instruction 14?
No.
Okay. Any exception on 15, Ms. Stone?
Yeah, I think it needs the principal or accomplice language in element 1, that the defendant, that on or about October 18th, 2024, the defendant, and then I think it should be inserted, comma, as a principal or as an accomplice, comma, and then did an act that was a substantial step. So I think that language needs to be inserted in there.
All right. And this was your proposed instruction?
It was, yes, Your Honor, just got up.
All right. And so just so that I have what your proposal is in full, after the word defendant, as a principal or as a accomplice?
Yes, Your Honor, both of those set within commas.
Okay. Mr. Kading?
Now I'm confused. So are they alleging that the defendant, Mr. Ali, was an accomplice to his wife's actions?
It's
This
charged,
is
I
his
think
instruction, right?
it is his instruction. I think that it is charged that way. I think that the state is alleging it at, not I think the state is alleging it as a principal, but I also don't want the jury to get confused when they are listening to Mrs. Ali's, that somehow they have to decide that one person is something more than the other person. And I think that that language is appropriate in that because it is irrelevant in terms of if they believe, if for some reason they believe that he is an accomplice over a principal based on the information, I don't want them to get tied up in that language. So that is an appropriate statement. And the state is arguing primarily that he is a principal, but that there is a concert of action between the two of them at the time these events are going on.
Mr. Kading?
And Your Honor, I don't know, based on what we've seen, how his actions, which were his own, he then is laid flat on the ground, not moving. If there's an allegation then that she did something, I don't know how he's an accomplice to what she's doing. Similar to what Mr. Leary was arguing, except my client being there and prostate on the ground certainly has nothing to do with what's going on with Miss Ali behind him.
All right. Anything further, Ms. Stone?
No, Your Honor.
All right. I am not going to, in Mr. Ali's instruction, include the language as a principal or as an accomplice, even giving all reasonable inferences to the state on the evidence that was presented during the course of the trial. I don't find that the evidence is that Mr. Ali, or it could be argued that he was an accomplice on the attempted murder to Mrs. Ali. And so I'm going to leave it as was set forth in instruction number 15. Mr. Leary, any exception on number 15? All right, then we are at number 16. Just a moment. Ms. Stone on number 16.
Yes, Your Honor, element one, same request of the state included the defendant, comma, as a principal or as an accomplice, comma, and then did an act that was a substantial step.
All right. Mr. Kading,
No objection to that.
Mr. Leary,
Based on the court's prior ruling, I think that assertion is appropriate.
with your standing objection.
Exactly.
Okay,
And then there is a typo. It should be element 3, not 4.
thank you.
Honor, you ask the defense lawyers to approach the microphone, please.
Yes, thank you.
Sorry, sir.
All right, number 17, any issue with that, Ms. Stone?
No, Your Honor, thank you.
Mr. Kading,
No, Your Honor.
Mr. Leary? Number 18 is the definition of assault. And the definition was different as was provided. It appears to me that at a minimum, the first paragraph in instruction number 18, which includes a sentence that is bolded, that paragraph would be included as the definition. I'm not addressing the next two paragraphs yet. So Ms. Stone, your instruction did not have that second sentence in the first paragraph. Any objection to the second sentence?
No, Your Honor, should have, thank you.
All right. And so just talking about the first paragraph, Mr. Kading, you proposed that language that the second sentence be included. And so you agree with that? First paragraph only, instruction 18.
I don't know that the second sentence, actually, I think it's bracketed, right? I don't know that that's something that's going to be argued in this case. That it's an offensive touching. Usually we use that in a lot of other kinds of cases.
I'm talking about the language of touching or striking is offensive if the touching or striking would offend an ordinary person. I'm pretty sure you proposed that language. If you're not proposing it.
I'm looking for my instruction package.
Oh, that's not true.
Okay.
You did not propose that language.
Okay.
You proposed just through the end of the first sentence and then nothing further. I apologize for that. That was language that was proposed by the state. They gave the entire 35.50 WIPIC instruction. And so you want just the first sentence,
Well,
or that's what you believe is appropriate under the evidence is what I mean.
I think that that's what we're talking about is a harmful touching, not an offensive touching in paragraph 1. Their allegation is that there was actual bodily injury. So paragraph 2 talks. Can I move on to paragraph 2? I'm sorry.
No, we're just talking about paragraph 1.
I don't think there was any offensive touching in this case.
Aren't you arguing that, or aren't you going to request that I give an instruction that this was discipline or that could be a defense? And so isn't whether or not the touching is offensive associated with, it's not an argument related to your request that it was a defense?
Now that you mentioned that, on the assault 4 would be the appropriate definition.
Well, all right. Mr. Leary, any objection to including the entirety of just paragraph 1, including the language that I have, that one sentence that's bolded for instruction 18, just paragraph 1?
Okay.
All right. So as to instruction number 18, the entire paragraph will be included, and of course it will be unbolded. Now, as to the second paragraph is to be given in cases involving an attempt to inflict bodily injury, but not resulting in battery. That does not appear, from my perspective, to be what the evidence suggests, and that was, that language is not proposed by defense, it is proposed by the state. So Ms. Stone, I would like to know why you would want that included.
Yes, Your Honor. When we talk about the assault 4, I want to make sure, because we've spent so much time during the course of this case with Fatima, that all of these injuries have occurred. So when we're talking about the assault, those additional paragraph instructions make it very clear that when the jury then moves to look at the injuries to Isaiah, try and decide what level of injuries, if there is sufficient, if there's in fact injuries, those two follow-on instructions make it very clear that for the purpose of assault 4, no bodily injury is required. The state does not have to prove that bodily injury exists. And that helps clarify that for the jury because like I said, we spent a ton of time talking about the nature of the injuries to Fatima. And there is obviously a significant distinction between those two. I would also indicate that Mr. Keating introduced photos that certainly look different, I think, from the states, or maybe arguably look different from the states. And I don't want the jury to get caught up in whether, well, we can't really see them here, or we don't see any, so it says that it's harmful, and we don't know that there's an injury, so therefore this assault 4 didn't occur. Those 2 additional paragraphs make it very clear that the state does not have to prove that, and that is not the definition of assault. If there is no injury that is required in that case. And so I'm asking that those be provided. It helps the state more fully argue that, and I think it is helpful to the jury in making that decision.
Mr. Keating?
Well, again, I mean, we have video of the punch. It seems to me that that's covered by number 1, paragraph 1.
Mr. Larry?
I would object to the last 2 paragraphs. My concern is the confusion as to, the state wants this for purposes of the assault 4, which doesn't come up until instruction 39. And looking at the 2 convicts of 39 is they have to find that on or about October 18, 2024, the defendant assaulted Isaiah Williams. All they have to prove is an assault of Isaiah Williams in the paragraph defines assault as an intentional touching or striking of another person that is harmful or offensive. And so I think they certainly have the room to argue their theory as to why that has been committed. And my concern is that the inclusion of paragraph 2 and 3 will be detrimental and confusing to my client who is not charged with a misdemeanor assault.
Ms. Stone?
I'm confused, I suppose, I'm confused as how that would be detrimental. Arguing the law as it applies to the facts in the case would be detrimental to a defendant. Paragraphs 2 and 3 are the law of the assault. It is a definition for assault. It is clarifying information for the jury. And so it is confusing to the state how providing a correct statement of the laws, especially as it relates to assisting them for Isaiah, detrimental to Mrs. Ali when there is a clear standard for Mrs. Ali as to the nature of the injuries that have to occur or the intent for those types of injuries to occur, whereas assault 4 is relatively silent about that. So that argument doesn't make sense to the state in terms of how it becomes more detrimental at all, let alone be more helpful to the jury.
All right. As to the 3rd paragraph, I am not going to include the 3rd paragraph. That is the language, an assault is also an act done with the intent to create in another apprehension and fear of bodily injury, and which in fact creates in another a reasonable apprehension and imminent fear of bodily injury, even though the actor did not actually intend to inflict bodily injury. No inference from any of the evidence in this case relates to that portion of the definition of assault. And the WIPIC 35.50 indicates that the 3rd bracketed definition should be used if there is evidence that the actor's intent was not to inflict bodily injury, but only to create the apprehension or fear of bodily injury. And the evidence that has been presented in the light most favorable to the state is the 1st paragraph definition of assault, that it's an intentional touching or striking. And that is the evidence that has been presented, not that there was apprehension or fear with no actual physical contact. So I'm not including 3. And I am not going to include paragraph 2 either. The WIPIC indicates that that paragraph, which indicates an assault is also an act done with intent to inflict bodily injury upon another, tending but failing to accomplish it, and accompanied with apparent present ability to inflict the bodily injury if not prevented. It is not necessary that bodily injury be inflicted. As it relates to the assault 4, there is no burden on the state to address bodily injury. It's whether or not there is, I want to get to the language. They have to prove that Mr. Ali assaulted Isaiah defined as an intentional touching or striking of another person that is harmful or offensive. And the second paragraph is not consistent with the evidence that's been presented. And I don't believe it limits the state in any way from arguing their case or confusing the jury, because the other assault charges, which require more than just the touching or striking, are clearly set forth in the elements, and the court knows that the state can properly differentiate between the assault charges. So
would the court consider adding the last sentence? It is not necessary that bodily injury be inflicted at the end of that first paragraph.
Mr. Kading? So she's talking about using the last sentence in the second paragraph and putting that as a last sentence in paragraph 1.
I don't object to that.
Mr. Larry?
I do object. My concern is just, my client's not charged with misdemeanor assault, and my concern is that it runs contrary to what the state has to prove for assault 2. I understand that there are individual instructions laying out the elements of assault 2, but we're then providing them with a definition that is in conflict with that, with respect to the specific. I mean, I think it gets, I would just want this to be clear that we are talking about an allegation of the assault 4, and that's what that sentence applies to.
All right. To ensure, I am not going to include that sentence. I understand why the state is seeking that. Again, as it relates to the charge of assault in the 4th degree,
Judge said
the
no.
state's burden is to prove that there was an assault, which is the intentional touching or striking that is harmful or offensive. I do not believe that the jury is going to be confused as they go through this process and apply that definition to the different levels of assault that are alleged in this case. And I believe it actually would be a misstatement if I added that sentence to the first paragraph. I think it could be construed as a misstatement of the law by putting it together like that. All right, instruction 19. Any issues with that instruction, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
There you are.
Number 20.
Just changing Ms. Ali's name in element.
Oh, thank you. Yes. With that change, removing the date of birth and putting in the name, any issue with number 20, Mr. Kading?
No, Your Honor.
Mr. Leary?
No, you are.
Any issue with number 21, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, you are.
All right. Instruction, as I indicated yesterday, I have instruction number 22, which was proposed by Mr. Kading. He then proposed another instruction yesterday that I did actually add into my draft instructions, but it was after I had sent it to my judicial assistant to print these. And so I had not wanted to reprint everything and renumber everything. But the other instruction that was presented, the difference is that for the lesser included, it was assault in the 2nd degree or assault in the 3rd degree. And as I go through the instructions, if I give those as lesser included offenses, I would include that language in what is currently instruction number 22. So I hear argument as it relates to the request for the lesser included offenses. Ms. Stone?
Sorry, just to clarify, are you asking for the substantive argument on the lesser included?
Yes.
First? Okay. I think that the substantive argument on the lesser included for assault in the 2nd degree is appropriate. I believe that would be Mr. Ali's 23A.
Yes.
I think that is appropriate. I don't think that assault in the 3rd degree, however, where it's been alleged by strangulation, is necessarily appropriate. The assault in the 3rd degree is not a lesser included of assault in the 2nd degree by strangulation. As the state was going through, and certainly I think different minds can differ, but as I went through it last night and was looking at it in the manner that it is alleged here, I don't think it can be the argument that only assault in the 3rd degree occurred if the jury believes the state's evidence in the way that it has been presented. I think they could believe that assault in the third degree also occurred, but not that it only occurred in this case, based on the argument that it is done as it relates to Mr. Ali by strangulation. So I don't think that assault in the third degree is appropriate in this case.
Mr. Keating?
And Your Honor, I think that third degree is appropriate in a case like this where clearly we have kind of a mob of people and a attack from behind that was seen in this case from Isaiah and him having a struggle with his daughter. I think it's entirely possible that there may have been a lack of recklessness or intent, obviously, which could still leave us with, well, maybe he shouldn't have put himself in that position. It was a negligent act that caused the assault, which would have been what happened after he was hit. And at that point, I think that an assault 3 instruction is appropriate if it goes towards culpability and mens rea, which in this case it clearly does. If he could have known what he was doing was wrong, but didn't. At that point, he was aware of it, and maybe it shouldn't have been happening the way it happened, but it's hard to tell what any person would do under those circumstances. And I think that's kind of what the assault 3 definition gets into. What would a reasonable person faced with the exact situation, what would have happened? And I think that's where assault 3 comes in and covers it with a negligent act.
So when I was looking at this issue, your proposed language is for the assault in the third degree with criminal negligence causes bodily harm to another person by means of a weapon or other instrument or thing likely to produce bodily harm. Clearly, there's no weapon, that there's been any evidence of any weapon. I don't know. I didn't see any evidence of other instrument. Instrument is defined in the Oxford Dictionary as tool or implement. I did not see a tool or implement. And then it says, or thing likely to produce bodily harm. And of course, other instrument and thing are not defined in the WIPIX, which is why I just looked up the definition of these terms in the dictionary. And thing is defined in the Oxford Dictionary as an object that one need not, cannot, or does not wish to give a specific name to. And so
I don't know if it's helpful. I apologize for interrupting the court, Your Honor. State versus Altman very specifically says that your arms and or hands do not constitute an instrument or thing that is actually out of Thurston County. And so insofar as that is the concern, whether arms or hands would constitute that or meet that definition, they do not. So as it
well, just let me stop you there. That's what I was getting at and asking Mr. Keating as to why he believes that this instruction would apply under the facts, because you did not argue that initially when.
I did not. I apologize, Your Honor.
Take a look and see in just a second. Okay, I may have included a paragraph in here. There's a paragraph that says, with criminal negligence causes bodily harm accompanied by substantial pain that extends for a period of sufficient to cause considerable suffering. And I think I did include that. And I may have incorrectly put in the weapon or other instrument language. And I would agree there is no weapon or other instrument.
So your proposed instruction did specifically say by means of a weapon or other instrument or thing likely to produce. And so that is what I have is that was on the 1 page,
right,
separate sheet instruction A. So now you are indicating that, what are you indicating your proposed language is then?
It would be a person commits the crime of assault in the third degree when he with criminal negligence causes bodily harm to another person with accompanied by substantial pain that extends for a period sufficient to cause considerable suffering. And it appears that that would be consistent with what the medical records show. If we consider, I guess it depends on what a period sufficient to cause suffering is, and if it's 3 days then or 4 days that are noted in this case, then I think that would be a good restriction.
And I do have an unpublished case that I think addresses that, Your Honor. Again, obviously it's unpublished, and so if that's helpful to the court, it's State versus Brown. State's reference is Lexus, so I apologize to the court, but it's 28. Well, I can print it and provide it to the court. But the file number is, oh, it looks like there's a Westlaw reference too, excuse me. 2018 Westlaw 4959959. And the request, that was a assault in the second degree case by strangulation. The proposed request for the lesser included was with criminal negligence causes bodily harm accompanied by substantial pain that extends for a period sufficient to cause considerable suffering. So what Mr. Kading has offered here, and that is that was a Division 1 case, and the court there said to be entitled to an inferior degree offense instruction on this type of third degree assault, the evidence must affirmatively establish Brown did not strangle Guntow that caused her bodily harm resulting in substantial pain. The court went on to identify the evidence from witnesses who testified about the strangulation. And the court essentially said that the evidence does not show that Brown committed only the inferior degree offense of third degree assault to the exclusion of the greater offense of second degree assault. The conclusion that he committed third degree assault required the jury to selectively disbelieve parts of the victim's prior statements and her testimony. Disbelief of evidence of guilt does not satisfy the factual element of the test for an inferior degree instruction. Brown was not entitled to an instruction for third degree assault. So for those reasons, I don't think the third degree request is proper in this case. I would agree that the second degree, the lesser would be appropriate.
All right. Although certainly the court is not bound by any unpublished decisions, they can be instructive to the court as the court considers different legal issues. I would like an opportunity to read this case so that I can see if it informs my decision in any way. And also I would want Mr. Kading to have an opportunity to look at that as well. And so it is 10:10, a little early, but we'll go ahead and take a recess. I know that from what Mr. Leary indicated briefly to me this morning that he has a matter with Ms. Stone, I think in another courtroom. Potentially the parties could handle that while I look at this case, and that also will give you, Mr. Kading, a chance to look at the case as well. I'm going to attempt to make this a 15-minute recess. I know the lawyers will attempt to do that as well.
Okay, Maria, you cook
Thank you.
away as long as I
Oh,
can keep you entertained and busy while you're listening, you know. I used to do that all the time. I always had somebody in my ear when I was in the kitchen cooking, or every morning I'd get up and I'd turn on Allegedly Speculating when I went into the kitchen to cook Hector's breakfast, and I would listen to her while I was cooking. You know, it was just, and I knew she was going to be on at 12:30 every day. I always expected it. So I kind of like that. So I think that's what I'm going to try and do with the 3 o'clock time slot. Tongue-tied, 3 o'clock time slot, 3 Central is I'll just start every day at 3. And that way, you know, it'll be an expected time. And then anything we choose, whether we choose to do trials or, hearings or anything, you know, that it'll all be at 3 o'clock Central. Hey, Vamos, how are you? But yes, listening while doing things, Maria, is absolutely, I do that and I still do it. Hey, Indy saying hey. Okay. So she went and she read her little information.
In addition to the case, which was argued by Ms. Stone prior to our recess, I was also provided with State versus Coriel, 197 Washington 2nd, 397, a 2021 case by Judge Dixon from this court. I've read that now, and we'll hear any further argument. Mr. Kading, did you have an opportunity to review those?
I did have an opportunity, Your Honor, and I must admit it's a little confusing given our situation here. But it appears to me that I may have erred in adding assault in the third degree and should have added assault in the fourth degree. So it would appear to be a lesser degree of an intentional assault. So I'm going to propose it to be fourth degree.
So when you are making that argument, I think one of the distinctions that I want to hear about is these cases, both cases that were cited, discuss that the charge was assault in the second degree. And therefore, they were looking at the lesser and or inferior degree charge. And it is correct that in, at least specifically in the Coriel case, the Supreme Court said that the judge erred when assault in the second degree was charged, and it was charged by strangulation, that the lesser included to that charge would be assault in the fourth degree. in this case, the charge is assault in the first degree. And so I think the differentiation as to what is a lesser included or an inferior charge it's the analysis to assault in the first degree, not assault in the second degree. And so that's, if that makes a difference, that is something I would like to hear argument about.
Well, Your Honor, when I read RCW 1061.003, it says upon an indictment or information of for an offense consisting of different degrees, the jury may find the defendant not guilty of the degree charged in the indictment or information and guilty of any degree inferior thereto. So I don't think that the fact that it's charged first degree limits what the inferior degree crime could be.
Then why wouldn't your assault in the third degree be correct?
Well,
Lesser
we could include
under that theory.
Well, I think that one of the issues has to do with the mens rea element. I mean, the intentional is an element of first degree, second degree, and fourth degree, but not third degree, because that's a criminal negligence standard. And I note in these cases that were cited, there was no, in Coriel, there was a second degree to fourth degree, and third degree was not included. And I think that has to do with the allegation that it was an intentional act as opposed to a negligent act.
So what if I'm looking at Coriel, and I have it printed on pages. So I'm on page 12 of what was printed for me. I don't know if you have a printed version.
Yeah.
At footnote 50, it says, in sum, we have reaffirmed that the factual requirement for giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction will be given. The evidence, so I would like to know what evidence, separate and apart from strangulation, has been presented as it relates to the issue of assault, because that goes to the court's consideration.
Well, I mean, obviously there was evidence that he did grab her, and there was evidence in the video that he was touching her and trying to move her from one point to another, which could be considered an assault for these purposes. And regarding the allegations of strangulation, I think again that's something that requires an intent, which I'm not sure has been fully developed in this case.
All right. So just to be clear, you are withdrawing your instructions as it relates to assault in the third degree, and instead are requesting that in addition to the lesser included offense of assault in the second degree, which has been agreed to that there's not an objection to, and from the court's perspective, which is an appropriate instruction, you are requesting that the court give the definition or a elements instruction as a lesser included of assault in the fourth degree.
Correct, as a lesser degree of the initial charge. And I am reading in Brown where it indicates that it would be, could potentially be ineffective if I did not at least ask for that to be done. So I'm asking for that to be done. And obviously, that is my request.
All right. And before I hear from Ms. Stone again, Mr. Leary, this instruction does not apply to Mrs. Ali, but do you have anything that you are going to argue to the court? All right. Ms. Stone.
Thank you, Your Honor. Your Honor, I don't read either case essentially to say that once one charge has been done, we just then include every version of the lesser degree offenses. I understand now that counsel has withdrawn the assault third request and is making the assault four request. As I looked at Brown and as I looked at Coriel, and to be clear, the state provided Coriel to all of the parties and the court. The workman test is the same for each. And looking at the headnote 9 at paragraph 48 on Coriel, the Supreme Court there, and I would note the Supreme Court did identify that the issue becomes very confusing at times in application, even if the theory itself is relatively simplified. Implicit within Workman's reasoning is the idea that when there is affirmative evidence from which the jury can conclude that only the lesser included offense occurred, a lesser offense instruction should be given. The court goes on to say at the end of that paragraph, the test was never intended to require evidence that the greater charged crime was not committed, only that a jury faced with conflicting evidence could conclude that the prosecution had proved only the lesser or inferior crime. The reason that it was an error in Coriel with to not give the assault 4 instruction is because that in that case there was an argument that one, the defendant had used self-defense or used force for the purpose of self-defense or defense of his property, or that two, he did not actually strangle because he indicated that the evidence supported an inference that the defendant assaulted but did not strangle his girlfriend, in which case then the assault 4 instruction became appropriate. That does not appear to be the case here. So it's, I guess, confusing to the state why the assault 4 would be appropriate in this case, separate and apart from the assault 2 instruction as it relates to that. I don't think that we just continue to add, and I don't think Workman or Brown or Coriel stand for the proposition that we just continue to add lesser offenses each time. So I don't know that assault 4 is appropriate in this case either based on the facts that we have, but I do believe assault 2 would be appropriate as a lesser included offense. I was looking also at paragraph 45 and just some of these statements that were made from the Workman line of cases. Quote from Gallagher, a defendant may not be convicted of a lesser degree of a crime, which is included in a greater degree, unless evidence is adduced to sustain a conviction upon the lesser degree. And the quote from Foley, the lesser degree of crime must be submitted to the jury along with the greater degree, unless the evidence positively excludes any inference that the lesser crime was committed. It also talks about at paragraph 43, how we've arrived at lesser included offenses under the English common law. So second sentence of that, the common law rule existed to aid the prosecution when the evidence introduced at trial failed to establish an element of the crime charged. So let's say you had theft in the second degree charged, and then at testimony, instead of it being $750, somebody only testified as to $500. In that case, it would be appropriate. And I don't think that that is what we have in this case. So I don't think those are appropriate in this case as to assault 3 and assault 4.
All right, well, the assault 3 instructions have been withdrawn and will not be given. So the issue is whether or not an assault in the 4th degree is a lesser degree offense of assault in the 1st degree under the facts of this case. And I think that Coriel is the better case in its discussion, and of course it's a published case, than the Brown case, and attempted to be more clear than the Brown case as well.
Coriel is also a 2021, so it's post-Brown, and Brown did rely on that Fernandez, Medina, I believe, the language that Coriel was trying to clarify as well, Your Honor.
Correct. And the test that the court is to use when giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction is given. And of course, that evidence can come from any source. It doesn't have to be from a defendant testifying, and it can include evidence presented through questions on cross-examination or evidence that is presented by the state. Ms. Stone, as it relates to Mr. Kading's argument that there is affirmative evidence that would establish assault in the 4th degree, as it relates to what was on the video of Mr. Ali grabbing Fatima and then chasing after her. He had her when she was bent over and is grabbing her in some fashion prior to any evidence of strangulation. And that's what I heard Mr. Kading was basing his argument that that is evidence that would affirmatively establish, I guess, the theory that this was an assault, potentially was an assault in the 4th degree instead of assault in the 1st degree.
Well, I think for that to occur, that would have, for that argument to fit the case law as we have it, it would have to essentially account as two separate assaults, as it did in Coriel. Coriel case talked about there essentially being two assaults that were occurring instead of one ongoing. In this case, it's one ongoing assault. So I don't think you can argue that in the process of going to strangle someone, the second that you have grabbed them for the purpose of strangling them, then you're entitled to an assault force instruction, as if that is a separate incident from the entirety of the strangulation itself. And so I don't think that argument is consistent with the case law. If counsel is arguing that there is a separate assault, that essentially the first time his client grabs his daughter is the assault for, and that is an appropriate instruction for that incident itself as it's separate and apart, then I would agree with that assertion in terms of a lesser included offense, but that it did not apply to, in that case, the second grabbing of Fatima and taking her to the ground. I would not agree that the assault for applies based on that set of facts.
Will you state that again?
Yes, Your Honor. So when we are looking at the video, there is the initial contact with Fatima where Mr. Ali is described as aggressively grabbing Fatima, and that is when Isaiah tries to defend Fatima and separate Mr. Ali from Fatima. As you see in the video, Fatima falls down and she's attempting to run away, and Mr. Ali turns and punches while Isaiah is then flying backwards. Mr. Ali goes after Fatima again and puts his hands on Fatima, and then they start to go to the ground, and that is where the strangulation occurs. If Mr. Kading's argument is that the assault for is appropriate based on that initial grabbing of Fatima where Isaiah, then I think that is appropriate. If that assault for request is based on the moment he puts his hands on his daughter to begin strangling her, that the strangulation has not yet happened, and that assault for is essentially the initial touching and it has not yet developed into the strangulation, then I don't think that is appropriate. When we're talking about Coriel, the facts in Coriel is that there were essentially two separate assaults that occurred, and the court said as it related to this other argument, the court could have determined that these markings on the victim's neck in that case came from something else and not as a result of the incident where the victim described being strangled, that there were essentially two separate. In our case, the state is arguing that this is a common scheme or plan and that there are not two separate incidents. If that is Mr. Kading's argument, then I would agree that he would have a an argument for assault in the fourth degree as a lesser included, if that initial contact is what he is referring to, but not if he is saying it is at the start of essentially the second contact, and therefore he's entitled to that, because certainly it goes well beyond that. He doesn't simply touch her and walk away from that. So I don't think assault for in that case is appropriate.
Mr. Kading?
I have no response. Thank you.
All right. All right. Based upon my reading of State versus Coriel, in that case, the Judge Dixon, who's pictured here in our courtroom, was reversed. It was a case where the charge was assault in the second degree. Defense offered an assault in the fourth degree charge. And in an opinion that they said was to help clarify the law, it still continues to be somewhat, not trying to impugn this decision, but it is not, frankly, still completely clear. And I think that that is clear from also what the lawyers argued, that it's not clear necessarily. But the very last paragraph of this decision under right before section C, and it is at paragraph 50, it says that in this case, they are reaffirming that the factual requirement for giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction will be given. It's not my job to weigh the evidence or to indicate, as I put together the jury instructions, how the court thinks the evidence has been presented. In this case, I do believe that there has been some evidence that has been presented that affirmatively establishes a theory of assault in the fourth degree after reading the Coriel case. And therefore, I will I will give that as a another instruction for a lesser crime. So I want to go back to instruction number 22 on the packet. I am going in the first paragraph.
And I know the court is looking at that now. The state had, only tried to find it last night and could not, that if the court was doing it for 2 lesser crimes, whether it should be the lesser crimes of assault in the second degree, and then whether it should be an and or an or. I plainly couldn't find that, and I was concerned there might be confusion as to that. So the request of the state is going to be to essentially restate that first paragraph a second time without that first sentence, so that it is very clear. So it would read the first paragraph as it says, the defendant is guilty of the lesser crime of assault in the second degree. If after full and careful deliberation on the charge of assault in the second degree, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crime of assault in the fourth degree. So just essentially restating that to not run into that issue of whether an and or an or confuses the jury as to application. And then the third paragraph would remain the same.
Mr. Keating?
Your Honor, I would not object to that, but I will defer to the court.
All right. That proposal seems appropriate to me, and I think will be the least confusing, will be as clear as possible for the jury as it relates to their analysis. All right. Instruction number 23. That is 23 and 23A. Those are the, that's the definition of assault in the second degree. And I just want to indicate that I am incorrect in the note that I wrote. The assault in the second degree under WIPIC 35.10 would, except we're using 23A, correct? I apologize. I heard about that before I started the analysis about what the lesser degree charge would be. I believe that there was an agreement to 23A for the definition of assault in the second degree.
Yes, I agree that would be correct for 23A. If we're going back to 23 regarding strangulation specifically.
But then I don't have to, just a moment, I apologize.
Yes, sir.
I think that instruction 23A addresses both.
Yes.
And so I don't need to get to instruction 23, but I was incorrect about the word intentionally. I indicated in my note on 23 that it was part of the WIPIC, but it is not for the strangulation prong.
Yes, sir. So agreement on 23A if we're leaving that as it's written.
All right. And then now, Mr. Leary, you can make your argument about the word intentionally.
The other problem is that my client is not charged with recklessly inflicting substantial bodily harm.
That's correct. And it's not in part of the elements instruction either for her. The only thing in the elements instruction for Mrs. Ali is the strangulation.
Right. So I guess if we're giving 23A, do we make it clear that it only applies to Mr. Ali?
No, that's the definition of assault in the second degree. It can happen in one way or it can happen in the other way. And it's the elements instruction that tells the jury what the state has to prove as to each defendant. And it only addresses strangulation as it relates to Mrs. Ali.
So I haven't done a lot of code of trials, so this is kind of why I'm just pausing, because my concern is that the definition of assault in the second degree that includes recklessly inflicts substantial bodily harm, I understand why it's being given as the lesser for the assault in the first degree, but we would never include that. If I'm standing here alone, that language wouldn't be in the definition because it's not charged for my client. And so I understand what the court is saying is it's too convicted to my client. I don't know that I'm wrong, but I just have this concern that the definition to the jury for assault in second degree includes an alternative that my client is not charged with.
definition defines assault in the second degree, and it indicates that for the purposes of this trial, that assault in the second degree is defined in two different ways. The elements instruction is clear as to how Mrs. Ali is charged. She's not charged, or it's not, the state does not, could not prove that she committed assault in the second degree if she intentionally assaulted another and recklessly inflicted substantial bodily harm, because that's not part of the elements in the elements instruction. But Ms. Stone?
I agree with that, Your Honor. I think the word "or" there specifically for that purpose, and when we get to the to convict, which is what the jury has to determine the state has proven or disproven beyond a reasonable doubt, that specifically addresses that issue for Mrs. Ali.
And so then 23 is not given. So the issue is to the word intentionally. So instruction 23 pertains to WIPIC 3510, which does not include the word intentionally.
Correct.
However, if you go to the to convict,
Right.
35.19.01, it does include the word intentionally. And so I requested that those two are consistent, and thus I included the word intentionally as well, even though it's not in the WIPIC as currently formatted.
All right. And that is what I would indicate that I did understand that when I reviewed your instructions between them. But Ms. Stone,
It feels redundant because that instruction or that word is in assault already that they will have just, I think, been instructed on. I don't know that it particularly matters that the WIPIC didn't include it, and I assume that that is why, since it is included in the assault definition itself. So it feels redundant.
all right. I am not going to add the word intentionally to 23A. After the or, it would be, the request is that I put the word intentionally there, intentionally assault another by strangulation. That is not in the pattern instruction. I don't have to give the pattern instruction, but there's not going to be any confusion. The definition of assault is contained herein, and the elements instruction includes the word intent or intentional. There's not going to be any confusion, and I will use the pattern instruction. Any issue with number 24, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
25 and 26, any issues with those, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
All right, on number 27, the proposed instruction from Mr. Kading, just a moment here. Not sure which packet that came in. Well,
So, Your Honor,
I think I added the language of the lesser included crime of assault in the second degree. I believe that I added that. I didn't know if that was appropriate or not. I couldn't find the WIPIC that might apply to that.
and I think it's I'm looking at the courts, I think it indicated instruction number 27 state. I don't think the state.
No, it's not. It's
Oh,
not a
okay.
state proposed rule.
27A then, if we're looking at that essentially instead, I think that is the modified 35, WIPIC 3512 and 3519.1. I don't have, oh, I'm sorry. We talked about it last night. I think the state would be requesting, as it is the alternative means for Mr. Ali. First of all, obviously, Fatima's name would be Fatima Ali, and that change would be made. So it'd be 27A using the affirmative, or excuse me, the alternative means, but I think it should be modified in this way instead. Each of the following elements of the crime must be proved beyond a reasonable doubt. One, that on or about October 18th, 2024, the defendant, comma, it should be then 2, that the defendant intentionally assaulted, sorry, I'm backing up. On or about October 18th, the defendant, on or about October 18th, 2024, semicolon, 1A, intentionally assaulted Fatima Ali and thereby recklessly inflicted substantial bodily harm, or B, intentionally assaulted Fatima Ali by strangulation, semicolon, and 2, that this act occurred in the state of Washington. If you find from the evidence that element 2 and either element 1A or 1B have been proved beyond a reasonable doubt, and then the rest of the language is the same as to element 1A and 1B.
Can you print that out?
Yes, Your Honor.
And I want to make sure that I understand the proposed language. And I should have said, can you print that out, please?
I understand.
Okay.
Thank you.
All right, so I'm going to come back to that instruction. All right, number 28 is the elements instruction for assault in the second degree as charged for Mrs. Ali.
Just the name change from the state, Your Honor, for the name spelling out from the state.
So you agree that the word intentionally should be included?
Yes, Your Honor, and it is
Okay.
listed that way in the book.
Yes, okay. Any issue then with 28, Mr. Kading,
No, Your
Mr. Larry?
With the inclusion of intentionally, the change to 15 will be done.
Okay. All right. Next is instruction number 29, which is the definition of unlawful imprisonment, which is WIPIC 39.15, and whether or not the language without legal authority is properly included in this instruction.
No objection from the state, Your Honor. I think that is correct.
All right.
No objection to being.
So that will be used. Any issues with 30 or 31, Ms. Stone,
No, Your Honor.
Mr. Kading,
No, Your
Mr. Leary?
No, Your Honor.
32 and 33 are the elements instructions on unlawful imprisonment for both Mr. Ali and Mrs. Ali. The difference between the state's instruction and each of the defendant's instruction is what I included in here as paragraph 5. And then at the top, it would be whether or not there's 5 or 6 elements. Ms. Stone?
I believe the state changing Fatima Ali's names in both 32 and 33. And the principal or accomplice language is charged in each of those cases as well. And so I think the principal or accomplice language should be included on element 1.
All right, and any objection to paragraph, or number 5?
One moment, Your Honor, please. I made a note, now I'm trying to understand my note. I guess I was, in terms of element 5, I had a question as to if we know from that the authority when you are restraining your child in the manner in which it was restrained is not legal. So I guess that's my question, what the intent is for defense counsel's version of it. If the argument is going to be that they have the authority to do so in that manner, that they believe they have the authority to do so in that manner, which to the state would be a jury nullification argument. So I guess my question is, why is element 5 being proposed when that is without legal authority to do so in the manner in which it was done?
Mr. Kading?
Well, Your Honor, it appears that the knowledge element would be important to include here, since it's obviously an element that regarding parents. If the state argues that the restraint was without legal authority, that's something you have to prove. They should have to prove that the defendant knew also that they did have no legal authority to do that.
Mr. Leary?
So the note on use says that element 5 should be used when facts exist to suggest that the defendant had a good faith belief that he or she has a legal authority. So parents would certainly fall within that category as to having the legal authority and whether or not their actions exceeded their legal authority as parents. And so the knowledge element should be included based on the comment and the note on use in the case law.
So since you're talking about case law, I looked at Warfield and Johnson related to this issue, and the cases indicate that the knowledge prong, this paragraph or this sentence would only be used where the defendants had a good faith belief that they had legal authority to imprison a person. And in the Warfield case, it was the bounty hunters who picked somebody up on an out-of-state warrant, and they believed that the warrant would have been enforceable here in Washington, but it was only a misdemeanor warrant, and so it wasn't, and they were charged with unlawful imprisonment. They were given, or should have been given, this instruction because they had a good faith belief that in fact they had the ability to take this Warfield, or the person that they had come to Washington State to get, they had the ability to take that person and return them to Arizona. And Johnson, in talking about Warfield, says that Warfield is unique and does not apply to most unlawful imprisonment cases, where there is no indication the defendant believed they actually had the authority to imprison the alleged victim. You wouldn't get number 5. And so is it your argument that because Mr. and Mrs. Ali are parents to Fatima, that they believed that they could restrain her in any fashion?
Not that in any fashion, but that they had the legal authority. So specifically to the acts of my client, she had the legal authority to restrain her runaway daughter in the fashion in which she did. And that the state has.
No, 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 no. I'm sorry. I'm going to back that up just a second. No, that.
To disprove.
I have to hear that again.
Is unique and does not
What
apply
did
to
he
most
say?
unlawful imprisonment cases, where there is no indication the defendant believed they actually had the authority to imprison the alleged victim. You wouldn't get number 5. And so is it your argument that because Mr. and Mrs. Ali are parents to Fatima, that they believed that they could restrain her in any fashion?
Not that in any fashion, but that they had the legal authority. So specifically to the acts of my client, she had the legal authority to restrain her runaway daughter in the fashion in which she did. And that the state has to disprove that she was acting with knowledge that the restraint was without legal authority.
All right, Mr. Katie?
Your Honor, I would concur with that the parents obviously have the right to restrain the children to a certain degree. If the degree is not met, then that's the state's argument regarding why it was unlawful. So I would ask that this be included.
Ms. Stone?
Yes, Your Honor. So even by the information cited by Mr. Leary, there has to be evidence of a good faith belief. Status as parents does not create evidence of a good faith belief. There's been no testimony. There's been no indication of that in this case. Both Mr. Ali and Mrs. Ali strangled their child. That is outside the bounds. And so insofar as at least the state, and maybe it is over interpreting Mr. Leary's argument that his client believed she was able to do so in the manner in which she did. I don't know if that is intended to branch out at closing into some sort of argument of what was the norm in their household, what is a culturally accepted, or something else. Those would be inappropriate. It essentially appears to argue that, well, their ignorance of the law made it okay, and the state can't prove that they didn't have ignorance of the law and that they decided that was a good faith belief, and there's no standard essentially provided to the jury about what a good faith belief is. So I don't think it's appropriate in this case. The manner in which they restrained her is not legally appropriate, and it is without legal authority. It doesn't prevent defense counsel from making the same argument, but that good faith belief language appears to be provided minimally and rarely at best. And in this case, the jury can make that decision based on the parental discipline instruction that I believe Mr. Leary may have proposed it as well. Mr. Katie proposed it. And that provides that information for the jury to decide whether they were acting within or without legal authority versus whether they had a good faith belief to act as they wanted to. So I don't think element 5 applies in this case.
All right. So I think I alluded to this yesterday when I was ruling on Mr. Kading's motion, I think, to dismiss the unlawful imprisonment charge. This is actually an issue that I have been thinking about as I've gone through the instructions. As I indicated, I read the cases that are cited in the WIPIC, specifically addressing this issue, and that is whether or not included in the elements instruction would be that the defendant knew that such restraint was without legal authority. And I referenced at that time the instruction 21, which is the defense to assault, that the force used was lawful related to discipline of a child, and that instruction specifically talks about that the jury may, but is not required to, infer that it is unreasonable to do any of the following acts to correct or restrain a child. And that is because parents have the right, the constitutional right to parent. Kids have no rights, basically, frankly, as it relates to that constitutional right, and parents' right to parent their children how they want to. Now, it can't be abusive, but parents have a great latitude to parent, and kids have no right. They don't have right to good parents. And that's why I say that kids have like no rights. But that's the state of the law. That's the state of our Constitution, and the freedoms that are provided to adults who have children. And I believe it would be inconsistent for me not to include number 5, since I have given the instruction about the discipline instruction. I do think that even though they are different and apply to different things, they are related. And there was no indication that I'm just going to say as an example, that Mr. Ali believed that he had a basis to, I'll stop there. I think these instructions are, that one sentence and that other instruction are related in some fashion. It would be inconsistent for me to not include number 5 because the parents do have the legal authority to restrain children. The issue in this case, of course, is whether or not that was an appropriate restraint. And that's for the jury to address. So I'm going to include number 5.
Thank you, Your Honor. I would ask to confirm prior to closing and ask the court to prohibit any argument. That would essentially be a jury nullification argument to the jury at closing, that these two parents in particular, based on their personal beliefs, had a good faith belief that that was okay, as if somehow in violation of the law is acting within the own scope of what they believe is okay. Somehow that's essentially a moral relativism argument. We can do what we want based on what we think is okay, even if that is inconsistent, and that somehow that then therefore qualifies as a good faith belief. I don't think that is appropriate. I also think that is, as I said, I think it would be a jury nullification argument. I also think it brings in cultural norms that are not appropriate in this case. And we've worked very hard to try and keep those arguments out from the jury so that they're making appropriate decisions.
All right. Well, there's been no evidence presented at all related to cultural norms in this family except what Fatima testified to. And so there can't be any argument that infers facts that aren't before the jury. And so I would think that neither Mr. Cady nor Mr. Leary are intending to make arguments for facts that are not in the record, or a reasonable inference from a fact that is in the record. Is that correct, Mr. Cady?
Yes, Your Honor.
Mr. Leary?
I certainly do intend to explore the concept of implied bias when establishing and evaluating credibility, which, in terms of how my client is perceived, not her values justify what she did, but in terms of evaluating the evidence and talking about the instructional intellect matters.
All right. Well, then I will take up objections during closing argument if the state believes that Mr. Leary is arguing something that is not supported by the facts that are in the record.
Yes, sir. Thank you. I think, was the court including the principal or accomplice language after defendant? I think I said it, but then we started talking about element 5, and I don't recall where we ended on that.
Thank you. Yeah, I haven't. As you said that, I wrote that into these instructions. Mr. Kading, any objection as it relates to number 32, adding the language as a principal or as an accomplice?
Again, as to the to convict instruction for Mr. Ali, I'm not sure that that's, is there an allegation that he was somehow involved with Mrs. Ali? Again, I think that this is a situation where she came in after he was no longer involved.
I mean, I don't actually think that I know that that is defense counsel's argument to the jury. I don't think that's consistent with the state's theory of the case. It's also not consistent with the video. She is actually there while he is choking his daughter. So I certainly don't think it hurts, it prejudices the defendant in that case. The state's ability to prove it is the same based on the evidence either way.
All right, Mr. Leary.
I don't believe the court gave the accomplice instruction for Mr. Ali on the attempted murder. I don't see how this is different.
And as to Mrs. Ali,
That's the instruction 33, based on court's prior ruling on accomplice. I think the language is appropriate.
All right.
Maintaining my jury.
all right. So as to Mr. Ali, as to instruction 32, I am not going to give as principal or as an accomplice. I don't believe that there, even with the inference to, and most favorable to the state as to the evidence that's been presented, that Mr. Ali was an accomplice to anything that Mrs. Ali ultimately did after he was no longer restraining, strangling, whatever word you want to use, Fatima, once he finally released her, once the bystander was able to get him to release her, I don't believe there's any evidence as to any interaction that he had with Mrs. Ali at that point, or until much later. So I won't include the language there, but I am going to include it in 33 as it is appropriate for the reasons I've already articulated. Any issue with 34 or, well, any issue with 34?
No, Your Honor.
All right. So the definition on number 3.
An enhancement. There's no mandatory sentence that is added to it. There is no change to that. It is not an essential element of the crime charged itself. And that's why the state's position in this case is that the crime charged is the same. The elements, the essential elements of that crime of unlawful imprisonment have been presented throughout this period of time. The domestic violence designation of that crime in and of itself is not the crime. We do have it, Your Honor. We'll print it. We can come back to that then.
All right. Also, just for the parties' information, as it relates to these instructions that we're looking at right now, I have number 37 as the instruction related to no duty to retreat. And then I have the necessary instruction in 38. I actually would give the necessary instruction. It will be moved up. It'll be before the, whether or not there's a duty to retreat if I give both of those instructions. Certainly I'll give the necessary instruction. And that was just my error in not having that be first. Any issue with number 38? Ms. Stone?
No objection to 37 or 38, Your Honor.
Thank you. And then those are your instructions, Mr. Katie. No issue. Mr. Leary?
No issue.
All right. On number 39, Ms. Stone, are you requesting that I continue to use initials?
I am not, Your Honor. I'm asking that you use Mr. Williams' name in that.
Yep. Yes. Any objection? Mr. Katie, just to changing that instruction only as to listing the name of the alleged victim instead of initials.
That's the court.
Ms. Stone, any issue with 40, 41, 42, 43?
No, Your Honor, none.
Mr. Katie?
No, Your Honor.
Mr. Leary?
Take issue with 41, with 6503. I don't think it actually applies to facts in this case. I think that pertains to the note on use that not use this instruction in the usual case. If there's a partial, like someone breaks a window and sticks a hand in, does that constitute enter for burglary? Here we're talking about her presence on the entire Timberline High School property.
Ms. Stone?
I don't think it hurts to have it. I would agree that following or the insertion of any part of the person's body, we could end it there with the period, and the remaining clause would not need to be, or clauses would not need to be included.
All right, I did not look at that, I didn't print that particular instruction as it relates to the WIPIC. And so I want to look at that. So I'm going to have to come back to that one.
So no objections to 42. And then the court also asked me about 43.
That's correct.
Okay, I do have an objection to that. So that is WIPIC 60.05, the inference instruction. Particularly the facts in this case. I think inference, note on use, the WIPIC committee says use caution in giving this instruction, see comment below. They talk about the concern about inference instructions generally. I think there's a particular concern by the defense for Mrs. Ali about the court telling the jury that they can infer that she acted with the intent to commit the crime against the person or property therein, particularly when there's a mixed motive here. The state's allegation is that the burglary charge was rise from her unlawful entry or remaining at school with the intent to violate the protection order. There's also an equally alternative explanation, which is why she was there, was to see her daughter, recover her daughter, and protect her daughter. And so obviously the state can argue to the contrary. I can argue my position, but I think particularly in this case, the inference instruction is improper.
Ms. Dunn?
I disagree, Your Honor. I know that counsel makes that argument after modifying the to convict instruction under 46 to try and say that the state essentially must prove and add an additional element of proof to the state, which is not required by law or by statute. The state need not elect any. I think there's a number of arguments as to what crime she could be doing. First of all, she's violating the no contact order. She knows exactly where Isaiah has run, assaulting Isaiah. She's already described an interaction with Isaiah, re-assaulting her daughter.
Also, I printed out and read many of the WIPICs involved in the different charges that are before the court, anticipating different arguments that I thought I would hear. I did not anticipate this argument. I have not read this WIPIC. I also optimistically thought we would conclude instructions before our noon break, and we are not going to. So that'll give me time to look at the WIPIC on both instruction 41 and 43 before I rule on those issues. Number 44.
State agrees we don't need it.
All right, so that instruction is withdrawn. Any issue with 45, Ms. Stone?
No, Your Honor.
Mr. Keating?
Nope.
Mr. Leary?
No.
All right. 46 is the elements instruction regarding the burglary in the second degree. The difference, I believe, between the two offered instructions, one from the state, one from Mrs. Ali, was that you have included the specific crime of violation of a court order. Mr. Leary, I'm going to go ahead and let you argue on that.
So I do believe I put in my trial memo that I had a question as to what was the specific underlying crime that my client was alleged to intending to commit. I did have a conversation with Ms. Stone. She indicated to me that it was violation of the protection order. If there are other crimes, then I would make a motion for a bill of particulars as to what crime. And then the question is going to be is whether or not the current jury instructions adequately inform the jury as to what crimes there are. And so I want it to be really, I want to know so that I can articulate and describe why my client, it's two parts: enter or remain unlawfully with the intent to commit a crime. And I think I'm entitled to notice as to what crime the state is alleging my client intended to commit as a part of the burglary. If it's beyond the protection order, I think I want to know what it is, and I want to make sure that the jury is properly instructed as to all of the crimes that the state is going to use to argue that my client committed burglary.
Ms. Stone?
Your Honor, when we had that conversation, Mr. Leary offered me a number of options. I said, yes, no contact order, a re-assault of Isaiah. With all due respect to Mr. Leary, I would characterize his response to that as poo-pooing some of those options as he disbelieves them, but the state clearly articulated that. We are at the end of trial. I just gave a number of indications of crimes that could be provided. The case law is very clear that that is not an element for the state to prove at trial in a burglary. I have provided now multiple times an indication of arguments the state will make as to what those crimes are. I understand that Mr. Leary disagrees with those on behalf of his client, but those plainly, you cannot add elements for the state to prove that are not required by either statute or case law. That is what counsel is intending to do here. It is not appropriate to put that in the to convict instruction because it is not in fact an element. And when we go to argue that to the jury should expressly know that that is not an element. And Mr. Lurie cannot argue that the state has to prove that. The jury does not have to elect which of those it is. The jury has to believe, and that is why the inference language in the prior WIPIC exists in the first place. So it is improper to add that as an element. There is not a bill of particulars at this stage of the case to provide to counsel that I have not already provided in the argument as we have sat here.
So I would just assure as the court reviews, the court will see note on use. It may be necessary to specify and define the crime alleged to have been intended by the defendant if the defendant so requests. That's in the WIPIC for 6004. So that's the basis for the request.
I'm sorry, which WIPIC are you looking at?
So I'm looking at the to convict WIPIC for burglary and
Yeah,
severity.
60.04?
Yes, 60.04, which is instruction 46.
Yes. What did you say the language says here?
So note on use.
Yes.
It says under some circumstances, it may be necessary to specify and define the crime alleged to have been intended by the defendant if the defendant so requests.
And then it says burglary in the first degree elements.
It says see comment WIPIC 6002 burglary in the first degree elements.
And then when you go down further to comments, under crime against a person or property, ordinarily the jury instructions need not specify the crime that the defendant intended to commit inside the burglarized premises. As an exception, that crime must be specified if it is material to the defendant's theory of case. Applying Bergeron, the Court of Appeals has held a jury instruction in a burglary case should not include the elements, even if the defendant has asserted a good faith claim. And then it goes on to say there is no statutory definition of what constitutes that crime. The Washington courts have construed the requirement with a, quote, common sense, end quote, view of the underlying purpose of the statutes to prohibit and punish conduct creating a risk of or actual harm to persons of property within a building. I have now provided that to defense counsel, again, multiple times. It is not required within the statute. It is not an additional element the state has to prove at trial that the underlying crime has either in fact been committed or for the jury to elect which of those possibilities that they believe could have happened or she was intending to go in, does not have to elect between those possibilities of behavior. So I do not think it is appropriate.
All right, and I also do have that instruction in front of me, and I thought I heard you say something different, Mr. Lair, which is why I had you repeat what you said. I'm going to use the instruction as proposed by the state. The WIPIC does not require, nor do these circumstances require that the court specifically indicate the language that was proposed by Mrs. Ali, that entering or remaining was with intent to commit the crime of violation of a court order, and I will not include that language. The instruction as was proposed by the state is a correct statement of the elements that need to be proven for the, that's the burden on the state. Number 47, any issue with 47, Ms. Stone?
It should have I think we have restraint provisions language should be coming after provision of the order. Gunnar, can we come back to 47 and 48? We modified the language on that and we're going to resubmit that. So we'll provide those to the court.
Okay. All right. Actually, we're going to start, it's noon, or it's a minute to noon. So we will come back and address the additional instructions. Mr. Kading, since you are now offering an assault in the 4th degree as a lesser charge, I need you to provide over the lunch hour the elements as to that lesser charge. I already have the definition because the definition's already been previously provided, as well as a proposed verdict form, since you are proposing those instructions, and I don't have those.
And I do think Ms. Stowe provided the initial request for those lesser included that may be in the packet that she handed up to the court just a few minutes ago. So, and to, I think it went to both Mr. Larry and Mr. Katie as well. It's just the hard copy that Ms. Stowe just provided.
I see.
The verdict form would not have been in there though.
All right.
We need a verdict form for the lesser included assault 4. Right.
That's what you're offering, right?
Yes,
Okay.
okay, I'm just trying to make sure I got it.
I don't want to create instructions. I want to use the instructions that the parties have submitted. They may be changed, but the court does not want to create the instructions.
And I'm not talking about 151, but the only question I had at the outset, and I think we'll just need to flesh that out, is whether we had enough letters for lesser included based on the number of lesser included that we're going to do.
Right, that's going to have to be modified based upon, I created the concluding instruction with one lesser included, because at the time I created that addition within that instruction, the only lesser crime was the assault in the second degree.
And I do think you had indicated, Your Honor, to delete a special verdict form, but I do think we need the special verdict form.
I added that language later on, which is, so look at the entire instruction. That's why I thought it should be deleted there, because it's included further down in the instruction.
Thank you, Your Honor.
All right, so we will be in recess until 1:30, and then we will take this back up. Mr. Leary?
I think there's one instruction left, but I don't think it's going to be in disagreement. So I don't know if we want to hammer it out now or not.
No.
Fair enough.
I also need to look at the two whippets that I talked about under the burglary charge. And this also gives me an opportunity to hopefully make changes that we have discussed as well, in case I have any questions as I'm making those changes to ensure that I haven't missed anything. So the court will be in recess until 1:30. Thank you.
All right, court in recess.
Yeah, the mom was like busting in doors and she was pushing the workers to get the doors open and all that stuff. The workers, the school employees. So yeah, I mean, it was okay. Yeah. So I do believe that the mom, with the different charges that the mom has,
And just compare it really.
she was the no trespassing order was on the school, and then when she ran into the school and ran through the doors, and then they were trying to shut the office doors to keep the kids in a safe, confined spot, she was pushing through those doors. The lady at the school said that she was putting her whole body weight on the doors to try to get them to shut because of those pneumatic doors, and she couldn't get them to shut fast enough. So no, the mom was not allowed on the school grounds. She was trespassed. And she was told not to come back. So the fact that she ran back into the school when all this was going on, I think that's where all this, a lot of her charges come in and, come in from. Okay. I'm going to zip through these.
Quick to make sure that it. I shouldn't say I didn't compare it, I did, but I want to ensure that I didn't miss something.
Just to be clear, the state did not modify it from the 1604 as it's provided in the WIPIC, Your Honor. Obviously, the only changes would be the selection or non-selection of any bracketed language. We didn't modify anything else that I can see or recall.
No objection, Your Honor. Thank you.
All right, that will be included. Next, I am going to the section of instructions associated with the burglary in the second degree charge. There was exception taken to the instruction currently number 41. The term enter includes the entrance of the person or the insertion of any part of the person's body or any instrument or weapon held in the person's hand and used or intended to threaten or intimidate another person or to detach or remove property. Mr. Leary took exception or objected to that instruction. I'm not going to give instruction 41. It does not apply to this case. Also, the WIPIC notes indicate that the instruction, this instruction would not be used in the usual case, as it does not define entry of the person in the usual sense. And the evidence that's been presented as it relates to the entry is that Mrs. Ali entered through the front door. She did not break in any fashion, and her entire person went inside, as well as her entire person being just on, well, that's in the building at the high school. So I'm not giving 41. There was exception taken to by Mr. Leary as to number 43, which is WIPIC 6005, which is the inference instruction. And I would indicate that I reviewed the Brunson case, which is the primary case that was referenced in the comments and notes on use from the WIPIC. And it indicates that there are three important limitations that the court should consider as it relates to the use of this inference instruction. As it relates to number 2 and 3, I don't find that there's anything in here that would be an unconstitutional shifting of the burden of persuasion. And certainly this is not attempted, so it doesn't apply to those things. So I think really the first factor is what requires the analysis. And it indicates when the intent of the crime more likely than not flows from proof of the illegal entry, the instruction is appropriately given, provided the inference would not be the sole proof of the intent element. In the Brunson case, it's actually a consolidated case with multiple defendants accused of burglary, different types of burglary actually. And in those cases, the defendants, there was evidence that the defendants had actually broken into a building, broken a window, 3-foot hole in a door, that type of situation. And that was circumstantial evidence related to their entry with intent to commit a crime. And the inference was appropriate. And Mr. Leary has argued that this case is different and therefore that the inference should not apply or should not be given, so as to not confuse the jury, and I think, and potentially to shift any sort of burden of persuasion. Although this case is certainly different, it is still appropriate to give this instruction because there is circumstantial evidence as it relates to her entry in the building, how she entered the building, when she entered the building, the notice that she was not allowed to be there based upon the letter or order from the high school and the like. And therefore, I find that it is appropriate to give the instruction related to inference in WIPIC 60.05, and I will include that. We left off looking at instructions 47 and 48. Ms. Zoe, on behalf of the state, had handed forward some new instructions shortly before our lunch break, which changed or added, I guess really added to the language as it relates to count 5 for Mrs. Ali. Mr. Leary, did you have an opportunity to review those new proposed instructions, which are to replace what currently are identified as 47 and 48?
I did have an opportunity.
And do you have any issues with, let's start with 47. All right. So I will give the new version of 47 on 48. I would indicate that the proposed language now includes applicable to the defendant in number 1, which had been an issue that you had previously raised. Do you have any other issues? All right, so I will give the 48. On the concluding instruction, which is really where we left off, 49 as well, I have, let me back up a moment. Mr. Kading sent me proposed verdict form and special verdict form based upon the assault in the 4th degree as a lesser crime from assault in the 1st degree. And he properly identified them as verdict form BBB and BBB-1. So I added those to the packet, and I added that information under instruction 49. I also then changed or added to instruction 49 an additional paragraph related to the second lesser crime. Currently, the version of 49 references the lesser crime of assault in the 2nd degree. I just copy and pasted that paragraph and changed the verdict form lettering and changed the charge to assault in the 4th degree. And also indicated that that would only be completed if they found Mr. Ali not guilty of the lesser crime of assault in the 2nd degree, or if after full consideration, they could not agree. That is when they would consider assault in the 4th degree. So, and then I had added a paragraph for both Mr. Ali and Mrs. Ali as it related to the special verdict forms. That language had not, those paragraphs follow the paragraphs related to the instructions if there is a lesser charge. I'm going to start by hearing from you, Ms. Stone.
Yes, Your Honor, I think I tracked what the court was saying on what I'll call modified 151, which is that instruction number, loss number 49. That all makes sense to me. Plainly, I think I need to see it in print, but what the court outlined makes sense. In terms of organization, I think I'm understanding it consistent with the court's description, and if it is consistent, and I have no issues with that.
And also, I'm going to hear from Mr. Kading and Mr. Leary. It is still a clunky instruction now, but there just is a lot to instruct the jury on as it relates to how they approach the verdict forms. I believe, and of course, you all will get the actual language later today, but I believe that it's consistent with the WIPIC language.
And I do think that instead of trying, as the court has done here, instead of trying to combine it essentially and consolidate some of that language, I do think it makes sense to simply repeat the language for each of those, so that if they start to feel lost, they can just go back to, okay, what do I do now if it's an assault court, and they can just restart that process essentially on its own. So I think that makes sense, even though it makes it lengthy.
All right. Mr. Kading, recognizing that you're not seeing it completely yet, any issue with the way that I described that?
No, Your Honor, it sounded, I too tried to follow, it sounded very, very much as good as it can be.
Mr. Leary?
No further comments.
Okay. So I'd like to go through the verdict forms to ensure if anyone has any issues related to the verdict forms. Verdict form A as to well, first I'm only going to go through Mr. Ali's verdict forms, so I won't repeat his name with every verdict form. Verdict form A, Ms. Stone, any issue?
I did not see any, Your Honor.
Mr. Kading?
No, Your Honor.
Special verdict form A1, Ms. Stone?
Just fixing the name.
Oh, I'm sorry, I have fixed the name on all of the special verdict forms. I did that over lunch as well.
Thank you, Your Honor. No other issues.
Mr. Kading?
No other issue.
Verdict form B is Stone?
No issue, Your Honor.
Mr. Kading?
No issues, Your Honor.
B1?
Not that the court hasn't already noted.
And that means that I changed the name.
Yes, exactly.
Mr. Kading?
No issues, Your Honor.
All right, so then on BB, Mr. Kading, you had proposed an instruction for BB, which is the lesser crime of assault in the 2nd degree. And it was not quite the WIPIC language. So I did use the WIPIC language in a proposed verdict form BB. You can see how they're differentiated. I have one proposed by Mr. Ali, and then I put one with the WIPIC language. Do you have any objection to the use of the verdict form that's currently identified as BB-WIPIC 180.05?
No, Your Honor, we should use the correct one.
All right. And Ms. Stone, correct, that's saying
That's the court. That's the court. Hold up.
all right.
They're drowning in there.
BB-1, Ms. Stone. And I have changed the name for Fatima in.
That is awesome, Cindy.
In that one. All right. And I'm sorry, Mr. Keating, any issue with BB-1? All right. So I used Mr. Keating's proposed verdict form BBB that he sent over the lunch hour. Did you have any issue with that, Ms. Stone? And that is for the consideration of the lesser crime of assault in the fourth degree.
No, Your Honor, as long as it conforms to the WIPIC as the court has previously identified it for BBB. I believe it does.
I believe that it does as well. All right, and as to BBB-1, in the issue, Ms. Stone?
No, Your Honor, and it does have that change already made to Ms. Ali's name.
All right, Mr. Keating?
I think it's right, Your Honor.
All right. Then we have a verdict form C. Any issue with that, Ms. Stone?
No, Your Honor.
Mr. Keating?
No, Your Honor.
C1, Ms. Stone?
No, Your Honor.
Mr. Keating?
No, Your
And then verdict form D, Ms. Stone?
No, Your Honor.
And Mr. Keating?
Honor. No, Your Honor.
All right. Now I'm going to switch to the proposed verdict forms for Mrs. Ali, starting with verdict form A, Ms. Stone?
No, Your Honor.
Mr. Leary?
No issue.
Special verdict form A1?
No, Your Honor.
Just one moment.
I'm not noting that. I understand the court's changed that.
Yes, I have. Mr. Leary? On A1?
If no objection, I will just take the motion now.
I'm sorry, could you?
Sorry, no objection, and I will just note that the court has acknowledged changing Fatima Ali's name to the full name in all the special direction. I will not respond again. That's that issue.
All right, thank you. Verdict form B, Ms. Stone?
No, Your Honor, no issue.
Mr. Leary?
No issue.
B1?
No issue, Your Honor.
Mr. Leary?
No issue.
C?
No issue from the state, Your Honor.
Mr.
No
Leary?
issue.
C1?
No issues from the state, Your Honor.
Mr. Leary?
No issue.
And then D, Ms. Stone?
No issue from the state, Your Honor.
Mr. Leary?
No issue.
And then E, Ms. Stone?
No issue from the state, Your Honor.
Mr. Leary?
No issue.
All right. So I do think that there's one last issue that we need to address. I do not like to assert myself in jury instructions or in legal issues. I think that's the lawyer's job, and this may be a non-issue, but it's also my job to instruct the jury correctly at the conclusion of a case. And on the unlawful imprisonment charges as to both Mr. Ali and Ms. Ali, they are charged, and then it says that there is a notice of domestic violence, but there are no facts alleged in the information as it relates to the issue of domestic violence. In the other charges where domestic violence is alleged, it has language to the effect, it is further alleged that the defendant, and it has either Mr. Ali or Mrs. Ali, did commit the above crime against FIA, a family or household member, as defined by the statutes.
Okay, so here, just for a funny break, I'm going to show y'all. This is me with short hair, okay? Yeah, that's me with short hair. Yes, I was very, very heavy. Yeah, I don't wear it well.
The unlawful imprisonment counts in both informations. I do not have that language in it. And so I don't know if that is an issue as it relates to the special verdict form for that count. And if it's not, then everything stays the same. I can take a recess if the parties want to look at that
We have a
issue.
moment.
Yes. I'll go ahead and take a 10-minute recess so the parties can look at that and think about that. Thank you.
All rise, court's in recess.
Okay, another break. But see, we got the luxury today. We got the Zoom button. She said 10 minutes. Let's see. Yeah, she got about 10 minutes in there. Yeah, I don't like hair on my neck being all hot and sweaty and stuff. So yeah, I'm not about, yeah. That's why I put
Ms. Stone?
Yes, Your Honor, I have provided copies of a third amended for Mr. Ali and a sixth amended for Mrs. Ali information that just alleges or provides that information on the unlawful imprisonment consistent with the notice of domestic violence, notice of domestic violence for count 3, which is consistent with all of the language up top, both on counts 1 and count 2, including the family or household member with the dates associated with that. I provide copies to defense counsel. I provided bench copies and a notice to file or copies to file with the court as well.
All right, thank you. Mr. Kading, as to arraignment on the third amended information?
Your Honor, I just have one more second.
Yes.
Your Honor, I'm going to object to the amendment for the following reason. The state having previously rested, I believe that the DV designation in this case would constitute an enhancement, not only as a element that they are asking to be proved in this court, but for future charges. It does have a lasting effect in terms of scoring offenses. And for that reason, I think that it's more than just a formality that this be amended at this point. I believe Mr. Leary has additional information.
Mr. Leary?
I would note an objection. State versus Pelkey, 109, Washington 2nd, 484 at 490, identifies a bright line rule. A criminal charge may not be amended after the state has rested its case in chief unless the amendment is to a lesser degree of the same charge or a lesser included offense. Anything else violates the defendant's Article 1, Section 22 right to demand the nature and cause of the accusation against him or her. Such a violation necessarily prejudices a substantial constitutional right within the meaning of Criminal Rule 2.1e, which is now Criminal Rule 2.1. Subsequent case law lessened that rule, where there was a situation where an amendment to the crime charge and its essential elements remained the same, but the date of the violation was expanded, and found that the changing of the date did not necessarily implicate the Pelkey rule, and thus the defendant did need to establish prejudice. So here we have a situation where the state is adding an additional element as to count 3 in my case, which is the domestic violence allegation. As they indicate in the proposed amended information, they are further alleging that my client did commit crime against FIA, a family or household member as defined. So under the Pelkey rule, it is not an amendment to a lesser included offense. This is after the state has rested. We just also note that this is the end of the 3rd week of trial, and the state has had ample opportunity to review the information. The court has identified repeated errors and mistakes in the allegations contained in the information, to the extent that we're currently operating under the 5th amended information, and the state is now seeking to go to the 6th amended information. Once the state has rested, both defendants have rested, and we've essentially completed the jury instructions and ready to proceed to trial. Or to closing.
Anything further?
No.
Ms. Stone?
Thank you, Your Honor. As the court looks at the third amended for Mr. Ali, count 3, and the court looks up to both count 1 and 2, which have been consistent. I would also point out that count 3 clearly identifies unlawful imprisonment notice of domestic violence allegation -FHM family household member after 7/1/2022. All of the associated RCWs That notice has been consistent throughout, regardless of what information we have been on. That same is true for Miss Zahraa Ali in terms of that language, so it is not a surprise. Council has been on notice of that. There is no prejudice to the presentation of their case. So it's not an amendment, as in something is being added. It was already in there. There's clarifying language following underneath of that count. It is not a additional change to what was previously charged already in that information. Notably, in terms of the counts 1 and 2 for both defendants, that language has already been in there with those same references, cross-referenced essentially in the same documents. So that notice has been there. There's no change in terms of adding family household member to the arguments or presentation of the case as counsel has inquired. When we talk about the Pelkey rule, the concern with the Pelkey rule is that the state then amends an information such that counsel would not have had an opportunity to properly ask questions, cross-examine witnesses, or address that evidentiary issue prior to the close of the state's case. That is not the case here. So I would disagree in terms of the Pelkey rule that it does not apply here. That is different. And when then that turns into counsel having to provide prejudice for surprise or some way to not prepare appropriately for their case. And that is not the case since it is already charged with the explanatory language in counts 1 and 2 and has remained so throughout. It is in fact charged in count 3 for the unlawful imprisonment for both of them, as it has been throughout. The explanatory language in the narrative fell off in a scrivener's error. So that is the state's position.
Ms. Stone, does the defense have to prove that they are prejudiced if I were to allow the amendment at this point in the trial? I don't know, and that's why I'm asking.
I believe that they would if it was either vague in terms of not knowing what was presented, or if it was not on notice at all. If it was either a surprise or it was vague and they were not able to be able to present that. Under Pelkey is if you were adding a charge altogether, such then that counsel couldn't have asked the questions that they wanted to ask on cross-examination. They couldn't have properly prepared to defend their case, etc. That is not what we have here. If I would say that the situation would be very different if it was only in the header and there was no other charge for which that information was relayed, or charged, so to speak. If that narrative language wasn't included anywhere else in that document, we have consistently had the same domestic violence charge tag added in each of counts 1, 2, and 3. We've discussed it as such. We've actually gone through the jury instructions and everyone agreed that that special verdict forms applied to each of those counts because everybody was operating under that same belief that that language was there. And so there is no surprise. There's no change to how counsel would have asked their questions. It applies equally to counts 1 and 2. And it is listed in count 3 itself. The explanatory language underneath was not also provided in a scrivener's error. So I would ask the court to decline the request.
Mr. O'Leary.
I'll direct the court and the party's attention to State versus Brooks, 195 Washington 2nd, 91 from 2020. Head note 7, 8, and 9. So basically, if the Pelkey rule applies, and then talk about it being a bright line rule, prejudice is not required. Head note 9 talks about where the Pelkey rule does not apply. The defendant has the burden of demonstrating prejudice under criminal rule 2.1d. And so I would just, so this is at 195 Washington 2nd, at the bottom of 97 through page 98.
Can you address Ms. Stone's argument that this is not consistent with the Pelkey rule and the bright line rule?
Yeah, so the Pelkey rule states, criminal charge may not be amended after the state arrested in its case in chief unless the amendment is to a lesser degree of the same charge or a lesser included offense. So adding the domestic violence allegation designator, it is not a lesser degree of the same offense or a lesser included offense. Anything else is a violation of the defendant's Article 1, Section 22 right. Okay, so and the only exception that I'm aware to the Pelkey rule is something that expands the date or modifies the date. So the amendment sought by the state is not a lesser degree, is not a lesser included offense, and does not correct the date of the charged allegation. So the addition of the DV designator is not permitted by the Pelkey rule. So we don't even reach the issue of prejudice.
I think that's where the parties disagree because it isn't an amendment. The state has not changed the charge. The charge on lawful imprisonment with domestic violence, a family household member has been charged throughout. The state did not change the charge. It did not up the charge. It did not add an enhancement to the charge. It is the same charge with clarifying language in the narrative. And that same charge is referenced, or that same enhancement, or not enhancement, that same designator is referenced throughout the document otherwise. So council has had notice to it. The Pelkey rule does not apply because it specifically is not amending or changing the charge that has been there since the beginning of this case.
All right. Can you, Mr. Leary, give me the cites to the cases that you referenced? I got State v. Brooks, 195 Washington, 2nd 91, which is 2020. The first case, which was 109 Washington, 2nd.
So that's Pelkey,
That's Pelkey. And what's the year of that case?
1987. So 109 Washington, 2nd, 484.
Yes. All right. And Ms. Stone, I recognize the argument that it's distinguishable. In addition to that, is there any case law that you want to cite that I should review? Although I identified that this was a potential issue, I didn't research it.
I have not had time to do that, Your Honor. I was trying to fix the information, so I had not had an opportunity to look at anything other than literally the court came back in after I came in with the information.
Okay, so would you like an opportunity to look at that? All right, so I'm going to take a, I'll take a approximately 10-minute recess. I'm going to look at these cases. As you may identify cases that you believe are important for my consideration, if you're able to either provide a copy of the case or the site to my clerk and, of course, to opposing counsel, I will look at those as well. Thank you.
All rise, court's in recess.
Yeah, William, I was doing a little research, and I think a lot of the hype right now with BK is the big document dump that's coming out. I mean, hundreds and hundreds of pages of stuff. And I do believe that all the facts that are coming out with that big document dump is very, there's a lot of creators that are reading through them page by page by page. And I'm like, not interested. And I wanted yesterday to be the end of my BK stuff. But then all these documents are coming out and I'm like, there's so much stuff out there. But I think I'm just at a point where I'm like, let the families and the victims have their peace. I think I'm done with Kohberger. I don't want to see him again. I don't want to deal with him again. Did he, Lois? Yeah, recovery addict, went through a lot of the docs. Yeah, I just kind of thought, I'm just like, I'm kind of done with it. This case should be, this case Monday will go to the jury Monday. They may not have a verdict until Tuesday or later, but I mean, whenever they have their verdict, but it's going to go Monday. Monday they'll come in, they'll do their closing arguments, they'll do jury instructions after lunch. And then they'll, cause they're going to have, there'll be 3 different closings because we have 2 defendants. So, and then it'll go to the jury after lunch, she said. So after they go through the jury instructions and everything, then they'll go to them, and that'll all be after lunch. So I just don't think there's going to be any way for them to deliberate on Monday. So they'll probably have to come back Tuesday to start deliberation. So, but yeah, I'm going to look for a new case for Tuesday. Or something coming up soon. Yeah, I'm ready to go on to something new. I'm tired of the old stuff, I mean, let it rest. That's how I am with Kohberger at this point. I'm like, let it rest. I'm ugh.
Joan, did you have any additional authority?
I did not, I didn't find anything conflict.
All right. Let me ask you this. The charge is unlawful imprisonment in count 3. What is the notice of the domestic violence allegation?
The notice of the domestic violence allegation is, I would argue, in the header itself, but in terms of what the provision is associated with that, it is also repeated throughout 1 and 2 with that same language specific to family or household member.
And I don't think my question was, I apologize, was very clear. So the cases, well, there are 2 cases, but they talk about the fact that the state should not be allowed to amend after they rest if it is to add really what's going to be an essential element of the crime charged. And so crime charged is unlawful imprisonment. And that's why I'm asking, what is notice of domestic violence? Is that a crime charged? Is that an enhancement? What is that and how is that different? Because it's clear that the essential elements describing what that is are not in the information.
Correct, Your Honor. The charge itself obviously is unlawful imprisonment. Every essential element of unlawful imprisonment is noted within count 3. I think the reason it's called, it's not an enhancement. It is not a separate charge. You can't just obviously charge notice of domestic violence without it being attached to a particular type of charge. So I would argue that it is a category of a crime. It's notifying that this is a particular type of crime. It is not an enhancement, though otherwise. There is no, for example, if the court goes into, and I may misquote my RCW, I believe it's 994A 533 or 535, if I'm remembering my RCWs correctly, that has the list of enhancements. Those are obviously not, domestic violence is not any one of those as a separate allegation. That's why it's listed, it gets listed as notice of an allegation because it is a classification of a type of crime versus an enhancement. There's no mandatory sentence that is added to it. There is no change to that. It is not an essential element of the crime charged itself. And that's why the state's position in this case is that the crime charged is the same. The elements, the essential elements of that crime of unlawful imprisonment have been presented throughout this period of time. The DV, domestic violence designation of that crime in and of itself is not the crime itself, and there's no essential element to the crime itself that has been charged as it relates to count 3. So I don't believe it counts as an enhancement. It's not listed as one of those enhancements in the RCW. It is listed as a separate designator. So for that reason, I don't think Pelkey applies for that purpose. And because Pelkey doesn't apply, then I think counsel has to demonstrate that they are unfair prejudice or really any prejudice to them in the presentation of their case or their ability to prepare, because I believe this falls more in the context of, say, Brooks, where there's a change to the date or something like that. Even in that case, I would argue to the court that that is an essential element of that crime. The date has to be something that you prove and you're preparing for. And in Brooks, it didn't count as that. So here, because the DV designator is not an essential element, it is an allegation, not an enhancement, not a freestanding charge, not a separate charge to that. Pelkey doesn't apply to that designation addition. And because Pelkey doesn't apply, then counsel has to demonstrate prejudice. And there is no prejudice to demonstrate here because it's already charged in counts 1 and 2. Just as it was charged in count 3, but it has that additional language identifying what that notice is in counts 1 and 2. And all of the questions that we have asked, and specifically defense counsel has asked throughout this case, whether the defendants are the parents of the alleged victim in this case. And so that doesn't change. I don't think they can demonstrate that prejudice. I think that would be the appropriate standard without having been able to find anything about a allegation specifically or an enhancement. Any enhancements were referencing like a school zone enhancement or a deadly weapon enhancement or a firearm enhancement, which automatically comes with an additional 3 years or an additional 5 years or an additional 24 months based on the nature of that enhancement. There is no additional time that automatically adds when you add that DV designator to this crime. So I think that prejudice hasn't been provided. I think it would have to be demonstrated, and I don't think it can be demonstrated here.
All right, thank you. Mr. Larry, anything further?
To some extent, there's a distinction without a difference. I mean, to say that this isn't an enhancement doesn't require, school zone enhancement or, additional mandatory penalties. I mean, the DV doesn't, correct me if I'm wrong, I don't have the SRA manual in front of me, but it's the state saying that if my client is convicted of domestic violence, attempted murder in the 2nd degree, that the unlawful imprisonment count isn't going to add a point to her score. That has a direct correlation as to her sentence. It enhances her sentence by a point, which can be quite substantial depending on, if this was a standalone charge. Well, even then, in the future, as Mr. Kading said, there is an additional consequence. There's a reason why the state is attempting to further allege, and that's because of the sentencing consequences here. And therefore, under Pelkey, it's clear it's not an amendment to a lesser degree or lesser included offense. It doesn't modify the date. There's no authority to suggest that they have the ability to amend post resting, the afternoon before we head into closing argument. Nothing additional.
Mr. Katie?
Just to clarify, Your Honor, regarding the future, as Mr. Leary mentioned, one of the changes that's been made recently is that if you have two domestic violence related events on separate days, neither one of them can ever be removed from your record. If someone has a prior domestic violence on their record and then they go to trial and they're convicted of the second, both of those they can't be removed from the record, can't do a vacate because you have two different days. So there are potential consequences that are long lasting from a DV allegation that are not necessarily manifest in this particular case in terms of the enhanced penalty now, but it's certainly going to affect you down the road. It certainly does have consequences. If it had no consequences, there would be no reason to make a further allegation of domestic violence. It would be a moot point and we wouldn't do it. But we do it, we keep track of those things, and it does have consequences beyond this case.
All right, thank you. So first of all, I indicated that, and I don't ever try and insert myself into the trial or raise issues for parties. I recognized this issue when I was preparing at the start of the trial. I recognized this issue when I was preparing before we ever came into court about how I was going to read the information to the jury. And I specifically went over with the parties how I was going to read the information to the jury. And I said it in such a way that I thought it might raise the issue to the parties, because when I talked about count 1 and count 2, I specifically indicated that I was not going to read the last sentence. Then when I got to count 3, I said I was going to read it as is. And I recognize that the parties are focused on so many things. I also didn't raise it until we were all the way through the jury instructions because I thought one of the lawyers might raise this issue, and I would not have raised it at all if I did not believe that it could have been a constitutional issue, because other issues, frankly, are waived or could be waived if not raised, but constitutional issues can be raised at any time. And the court wants to ensure that it is addressing issues that could be of a constitutional magnitude ultimately. But with that said, I didn't try and research the issue in advance. Again, thinking that the parties might be addressing the issue with the court. This is a situation where the state is seeking to amend both informations, as the information to Mr. Ali and the information to Mrs. Ali as to count 3, seeking to add a sentence at the end of count 3, being identical except naming each defendant in each of their cases. It is further alleged that the defendant, Ihsan Ali or Zahraa Ali, did commit the above crime against FIA, a family or household member, as defined by, and then it lists the statutes. As it relates to amending the information, the standard, according to the Brooks case, is abuse of discretion, and the court looks at whether or not, ultimately, and what I should be looking at is whether or not the decision is manifestly unreasonable or based upon untenable grounds, and whether or not it's, of course, most importantly, based on the correct standard. The state is required to allege in the charging document all essential elements of a crime to inform a defendant of the charges against him and to allow for preparation of defense. That's a constitutional right that each defendant has. In this case, the crime charged, under count 3 is unlawful imprisonment. There is not a separate crime of unlawful imprisonment domestic violence. That's not like a separate definition within the RCW. There is a notice of domestic violence that is included in the informations that have been at trial, that being a second amended information for Mr. Ali and a fifth amended information for Mrs. Ali. The rule allows for an information to be amended at any time before verdict or finding if substantial rights of the defendant are not prejudiced. I do not find that this is a situation where Pelkey applies. This is not a case where the state is seeking to amend to a new charge. In the Pelkey case, the state, after everyone had rested, moved to amend to a different crime, from bribery to trading in special influence. And that is not the situation here. And the Brooks case is a case involving sexual assault and misconduct against a youth. And in that case, the amendment was amending the date range. So I don't find that this is the bright line rule indicated by Pelkey, as I don't find that the notice of domestic violence is an essential element of the crime of unlawful imprisonment. And I do not find that the defendants have proven that they have, or that there is evidence that they have, their substantial rights have been prejudiced. And I indicate that because the defendants have been on notice with the specific facts as it relates to the issue of domestic violence from the other counts, including count 1 and count 2. And I know that those may have changed as to the degree or the type, but they have been alleged to be domestic violence charges, even as they may have been amended. And both of those, count 1 and count 2, has the language that it is further alleged that the defendant committed the crime against FIA, a family or household member. So they've been able to fully litigate the issue of domestic violence throughout the course of this trial, have been on notice with the information contained or with the facts alleged in the informations that have gone to trial. Again, second amended information for Mr. Ali and fifth amended information for Mrs. Ali. And therefore, although the evidence is closed and both sides have rested, I am going to allow the amended informations to proceed forward based upon the reasons I have already articulated. Mr. Kading, as to arraignment on the third amended information for Mr. Ali.
Your Honor, we will acknowledge receipt, waive further formal reading, and are pleaded not guilty.
A probable cause has previously been established. Pleas of not guilty shall be entered as to each of the 4 counts before the court for Mr. Ali. Mr. O'Leary, as to arraignment on the sixth amended information.
Preserving the objection, the defense would acknowledge receipt, waive further formal reading, ask the court to enter pleas of not guilty to the 6 counts.
Probable cause has previously,
Sorry, 5 counts.
it's 5 counts. Probable cause has previously been established. A plea of not guilty shall be entered as to each of the 5 counts before the court as to Mrs. Ali. And do you have the originals of the new information? Okay. Having addressed that issue, then there would not be a change to the jury instructions as we have addressed to this point. Almost 3 o'clock. I believe that I should be able to finalize the jury instructions in approximately the next 30 minutes, and then I'm going to have my judicial assistant review them just to make sure that they appear correctly and are correctly numbered. And they will be emailed to you by 4:30 today. I ask that the parties review the instructions and that the parties confer if you see any error, because even after all that, there can be a mistake in the instructions. If you see an error, I ask that the parties confer between themselves so that we can you can address it in an email that everyone's on and everyone has at least been advised of whatever the issue is.
Your Honor, as it relates to Mrs. Ali's, the change that we previously made to the 6th Amendment to fix it from North Thurston High School to Timberline reverted back to North Thurston High School on count 4. I wish I was making it up, quite frankly. I need to fix count 4 to reflect that it says Timberline High School as it previously was. While the court is doing that, doing the next 30 minutes, or the other option would plainly just to be to find it out. And that would be I would be fine with that. I don't think there's any confusion that we're talking about Timberline High School.
I think because I've already arraigned Mrs. Ali that it cannot simply be lined out. Why don't you have that? Why don't you prepare your new information, but bring it in? I didn't intend to keep the parties here while I'm working on the instructions. I think the parties should be able to attempt to go back to your offices and then the instructions can be emailed. But if you can do that, I definitely want to take up another amended information before Mr. Leary leaves.
Yes, Your Honor. Thank you. What? Yes.
So I will be in recess. My clerk will call me once that comes in.
All rise for some recess.
Okay, we're underwater. We're underwater. That's it for today. No court tomorrow. And yeah, Monday we will be back at 3:00. And yeah, Monday we'll have they'll do the closing and then jury instructions. And you want to sing to him, babe? You want to sing? Anyways, anyways, yeah. Sidebar. Squirrel. Get what? Swine? No swine today. No swine today. Yeah, we had no bacon today. There was no swine. So yeah. Anyways, I'm gonna go and I will see everybody Monday. And till then, y'all have a great rest of your weekend. Might be a pop-up live a little bit this weekend if we find any chases or anything on the Rubber Ramada channel. So yeah, just have your notifications on and hi babe. And notifications on, and if you don't mind, hit the like button on your way out. Y'all have a great rest of your evening, and see y'all later. Peace. Rubber out.
Life's a ride on a rickety old track.